Well, may pray, my lord, item number 69. Some at 2 o'clock. Yes. Well, in fact, we tried this matter on 2-3 earlier occasion, it did not materialize.
Okay. My lord, in 69, my lord, I have filed one affidavit, my lord, for the respondent 5. That may be called.
May I please,
Yes.
may I please, your lordship.
This item for
Item number 57, supplement motion, your lordship.
Just. Yes,
This matter for
Item number
listing in next week.
57, supplement motion,
just a moment. Yes,
your lordship. Some development is going on after filing of the meeting. It may come after 1 week.
27,
57,
57.
supplement motion.
Okay, 57. On the prayer made by both sides are represented, on the
Yeah,
prayer made by
take it
Mr. R.
up.
Mazumdar and counsel for the petitioner, list after a week. Okay, yes.
Well, I will mention this matter repetition
A prayer for listing, please give it to the court master. All prayers for listing, give it to the court master.
next week.
You have to make some adjustments.
My lord, it is for my lord, posting, my lord.
Give to.
I'm giving you a pleasure.
May I please, your lordship? Lordship, item number 17 of today's list, lordship. Matter may be adjourned for the day, lordship. 76 on
Okay.
Wednesday, lordship,
Pass over the day as prayed for by and counsel for the petitioner. Okay,
Lordship, in item number 18, Lordship, on last day, Lordship, an order was passed. If no instruction comes, then the authority will have to appear personally. But in the cause list, Lordship, it is showing as personal appearance, Lordship. That is why, just for clarification, I mentioned this matter, Lordship. We have received instruction.
item 18.
Yes, Lordship.
Okay. Okay,
Lordship. Wait, please, my lord. Sorry, Lordship.
May it please, my lord, I beg to mention item 47, 48 of today's list. My lord, there is an urgency pertaining to the matter. It may kindly be updated. My lord,
47, 48.
48. My lord, there is
I'll not update it, but let the orders be over, then I'll take it up. Because I can't jump the list, otherwise it will be chaos in the court. You see, I can't help it. If I jump the list, how will you like you are sitting here? I'll be calling item 20, then I'll be calling item 15, I'll be calling 20, and there's no absolute chaos. That is not going to happen, no. After the admissions are over, we'll take your matter. But I can't jump the list. It will be chaos in the courtroom. Correct?
All right.
Nobody will have any clarity what is going on in the courtroom. I'm taking up motion item number 1, then I'm taking up item number 15, I'm taking up item number 60. That's not how to conduct the court, no. Yes,
See, item number 12, lordship, in the prayer part, lordship, I have to add one line, lordship, in this lordship, to
Okay.
permission, lordship.
item 2,
Item 12, lordship.
12, okay,
Hello.
okay. After the mention hours,
May it please, your lordship.
yes,
I beg to mention item number 67 from today's list, my lord. My lord, we have filed an affidavit in reply, my lord. Yesterday we have filed, my lord. That
Get
may be
it.
called for.
get it. Yes, get it.
Highly obliged.
Please, your lordship, item number 34 of today's list, we have filed an affidavit in reply. Kindly allow us to take the matter.
Take-
Flash lordship.
Daily list item number 1, motion be.
May I please, Lordship. First of senior counsel, Mr. ASRS also is coming, Lordship. Item number 1 and 2 may be taken after some time, Lordship.
Okay,
May I please?
yes. Why should we entertain the writ petition for demarcation of boundary?
Not only demarcation, my lord. Question of settlement is also there, my lord. Our claim for settlement. Land has been allotted to us, my lord, in 2005. We are paying the revenue, my lord. Now, after 3 years of continuous position, my lord, final settlement ought to have been made. That was not.
And that will be shown this.
Not.
Okay. Mr. Aradin and counsel for the petitioner. Next, you'll be appearing in this matter, G. Hazarika, government advocate for respond number one, and Mr. S. Barbar, and government advocate appearing for respond numbers.
2, 3, 5, 6, but four is repetition of 3.
Okay, 2, 3, 5, 6. It is submitted that respond number 4 is a repetition of respond number 3. Next, the learned counsel for the petitioner submitted that pursuant to order dated 15/5/2023, he has filed an additional affidavit. So we can record the conditions of land allotment certificate. Next, issue notice of motion returnable in
4 weeks.
4 weeks. Requisite extra copies of the requisition be served on the state and departmental council in course of the day. As per the pendency of this requisition shall not be a bar for the competent respondent authorities to consider the prayer for the petition of the petitions for settlement in terms of allotment certificates issued to the petitioner.
Right.
But Mrs. Hazarika, in this manner, if the state goes on carrying on the affairs, we will be flooded with hundreds and thousands of litigations which will not be able to handle. You see, people apply for settlement, you don't do anything, people rush to the court. You have this online portal for all this settlement of grievances, you don't take these matters there. Let me put an order. The court is also inclined to issue notice on the government of Assam to the chief secretary to examine this issue, because in this case the petitioners had applied for and they were allotted land. What is that land? What certificate?
Land allotment certificate.
Land allotment certificates. And as the said process was not brought to its logical conclusion, the petitioners are before the court. First off, the court has observed that similar writ petitions are pending before this court. First off, therefore, the state is required to examine the reasons of failure on part of the revenue officials to bring the land allotment matters to its logical conclusion, compelling the petitioners to rush to the court. So therefore, the state, through its competent officer, shall inform the court about the measures they intend to take so as to prevent avoidable litigations to come to court. Next, for the learned government advocate and the learned departmental counsel shall transmit a copy of this order to the competent authorities in the government to bring the order to the notice of the said authorities. Because we are daily at least 2 or 3 matters are coming to court.
For may trigger. But if the petitioners are association of bus owners,
We issue a notice at this stage, you can't do anything.
Lordship
My lord,
will just look
in
at
fact,
the
my
third round of litigation, Lordship.
You
will
see, it may be fifth, but you see the government has a right. Earlier, the buses used to come into Paltamizar.
Yes,
Then it was shifted to Jalukbari. Correct?
yes.
In the town, if they want to regulate big buses to come in, how can the court give a its verdict that you allow the buses to fly there?
Lordship, there is a high court's order also, there is an order of the trial court also. They in 2019 at page 61, we have filed an additional affidavit. They on when they meeting.
You see, we have seen Dibrugarh. We have seen the Dibrugarh bus station in the middle of the town. It
No,
there
no,
has to be.
district scrutiny committee that has taken the decision is not the competent authority.
It's okay, but I'm not going to do anything more in this, at this motion stage.
Secondly, the bus station where it's shifted to is not yet ready. Lordship, we have now, we have at 56, 57, we have posted the photographs, and on 31/3, they themselves by letter, we have found today that it is not ready. Moreover, the competent authority has to take a decision. There is a proper, it has to be a notification in the official gazette.
But I'm not staying those at this stage. I'm only issuing a notice and notice on the prayer for interview.
Lordship, there was already a High Court's order. And there,
If there's a high court order, you file a contempt. If it's a successive writ petition, you see,
Right.
to ease the city, what you call traffic, some steps has to be taken, even if it is the discomfort of the a part of a class of citizens.
no, Lordship is correct, but
Dibrugarh you have seen,
yes, Lordship.
then you show us a way. You find out a solution, you will take it up tomorrow, day after tomorrow, you find a solution. You see, the authorities will have to do something drastic about it.
But the competent authority has to do it. Lordship. That is the question, and there is a manner.
We'll hear that, but stay I'm not giving at this stage.
Lordship, let me place again on day after tomorrow. Let me.
My lord, may I submit, my lord, the minutes of the road safety committee meeting is not under challenge here. I have given a copy to my lord. The meeting dated which was held on 22/2/2023, which is not under
How
challenge.
will these people know that there is a meeting held?
Because they were aware all of this, my lord. After this meeting, Lord of Lordship, the deputy
No, no,
commissioner
no.
issued the order, my lord.
No, citizen is not expected to know what meetings are being held.
Lordship
If
may
you have
issue
it-
notice, we will file our
If
affidavit, my lord.
you've done it, at least these bus owners,
Lordship, these are civil consequences. Lordship, some hearing has to be given. Lordship, some hearing.
My lord may issue
Because
notice, we will
otherwise,
file our
public
affidavit,
at
my lord.
large would be affected. Because
nobody will be affected.
no, and these are stakeholders.
I was also one of the persons who protested when the ISBT was opened in long back. Because at that time in my limited budget, traveling was something very distant.
Right.
Going to ISBT itself was a cost,
Yes.
correct?
Yes, Lord.
But then it happened
Yes, my lord.
and now we are happy.
But same decision was taken earlier. That was interfered. It was,
It's
it
a
was,
policy
the
decision,
High Court,
I'm
it
not
was
doing.
incorporated. in
I-
the-
My lord may issue
I'm
notice, we will
not staying
file
on policy decision right now. He wants to do it next week. Monday I may not be, I'll be traveling 17th. List on 17, 7/6/2023.
Lordship, except 7, my lord, as a part of my code number 1, my lord.
And Lordship,
Lordship,
It's a
if you
motion
give me
matter.
some time, I will file affidavit also.
Lordship, that I have given a letter that I received on today morning, 31/3/2023. It itself says, whereas the office had earlier issued so and so on 28/7 notifying the daily base value of Murlidhar Jalan station terminus to be ₹5,000. It is already under construction. Therefore, it is not ready for shifting as yet.
We'll ask them to give a.
Lordship, I will file my affidavit, my
No,
lord.
not affidavit, we can give instructions, because if the bus station is not ready,
My lord.
then he has a public interest in it.
However,
you
upon press
can't-
survey and evaluation, it is observed that the MJBT has been operating through financially in a depleted condition in terms of space availability owing to the ongoing construction work of overbridge.
This letter
and
is
storage.
by whom?
This is by municipal board.
I will get
I
instruction. my
have
lord.
given the letter.
Okay, we will. Mr. BP Varadhan, counsel for the petitioner, has submitted that in respect of the proposal of shifting of the bus terminus at Dibrugarh town, the decision was not taken by the competent authority. First off, he also submits that the Dibrugarh Municipal Board, by a letter written
On 31/3/2023.
31/3/2022 or 23, has written to.
Written to-
It's an order, but it's an order given.
You show me that.
We have given handed over the. We have.
Oh,
given-
sure.
Oh, yes, sir, I have.
Lordship, second paragraph, may I read?
Just a moment.
Point number 9, phrase extension to be leased to Sri Om Prakash for adjustment of dues. Since MGBT is not in a favorable yet for the full-time operation and settlement.
This is the valuation of the rectified daily base value.
Serial number 9.
What is a daily base value?
Yes.
What is it?
Yeah, I think this will be given in a settlement. So daily base value is the 5,000 for the settlement given. If the bus stoppage runs there, like ISBT, it will be.
So that means it will be a market or something like what you call a vending station.
Yes,
Vending station has got nothing to do with ISBT.
it's about the Muralidhar Jalan bus terminal. It's terminal given on a settlement.
Terminal is not run by municipality.
Yes.
Is it? Is it your case that municipality is running it?
No.
Then
Municipality, but it is I wanted to show that it is a
so
depleted
it's
condition.
okay. You see, there's a market. Maybe there's a market opening up and it has not been complete. They're therefore saying base value is not ready.
Yes,
Doesn't mean that
at
it-
page 56, Lordship, we have given the photograph, present condition. Lordship,
I'll get the
Lordship,
information.
just
Get the
have a
instruction.
look at the condition.
Uh,
Lordship will have a look at the condition of the page
No, it's okay.
56.
I'm asking them to give instructions.
Yes.
We'll take it up on Wednesday. It is also submitted that the,
Can you fix the matter?
just a moment. It is also submitted that the bus stand is not not completed not in a workable condition. And in this regard, the petitioner relies on the documents appended to the petition. Next paragraph. Prior to issuance of notice, Mrs. M.D. Bora Leonard, standing counsel for the transport department, shall obtain instructions as to whether the ISBT is in fully functional condition. And the manner in which decision was taken to shift the bus stand. List in the motion column on,
Fix the matter on 8, my lord,
not 8, the 9th,
9th, my lord,
9/6/2023.
my lord.
Deeply obliged.
We are sending you this, you want to file it by way of an affidavit.
Deeply.
I'm deeply obliged, my lord.
My pleasure, Lord.
Okay. I'll give a notice.
Let's may I pray for dispose of the representation filed before the respondent number 2.
No, I'm not disposing of representations like that. It leads to multiplicity of litigation. But Mr. S.H. Rana, counsel for the petitioner, as Barwal and government advocate appearing for respondent. For all the respondents?
Yes.
For the respondent 1 to 4,
Barring 5.
1 to 4. no. Against shifting of the Anganwadi center to the house of respondent number 5. The present petition is filed on Article 226 of the Constitution of India. You should notice a motion written in 4 weeks. Requisite extra copies of the representation be served on the government advocate in course of the day. Petition shall take steps within 2 days for service of notice on respondent number 5 by registered post with AD as well as by Dasti. By routing the process to the registry report upon service, affidavit of service of the parent. Next paragraph, the pendency of the representation shall not be a bar for the competent authorities in the social welfare department. Who will be taking a decision for that shifting of Anganwadi center? Who is the authority to take a decision? District Social Welfare Officer,
Yes.
District Social Welfare Officer, Bapeta with the bracket respondent number 3. To examine the, where is your representation?
Page 25. Before the director.
Oh, director is not going to take,
Director.
with
I'll
bracket,
trace-
NHS 7. Okay, list out of votes.
May Lordship, the shifted to the Ramapura High School campus, not the residential correspondent number 5.
So shifted to
Ramapura High School campus.
Ramapara High School campus. Okay.
Obliged, Lordship.
Item number 1. 1.
Earlier, your lordship, I'm sorry, madam, I was.
Yes, okay, someone, where is the APP?
We'll give copy, madam. We'll inform them, madam, copy already supplied.
Okay, the records are here.
Earlier, your lordship, was 16,220, that was not here, madam. Subsequently, we approved the code below my lord, and that was
No,
rejected. on my-
scan copy of LCR is available.
but I cannot see.
This matter.
The most one it has come.
No, page 39, we have always, we have called for the copy earlier.
So earlier,
Mhm.
but after judgment, some, by this time, some might have witness already examined. Our case is that they have not implicated us. That's why this is the case. So that will be required.
Okay, you have produced the, what you call the
Yes, fine.
evidence of the court.
Yes,
Where is that?
yes. Your lordship, item number 1, your lordship will find that is page 2811.
Page 28 onwards. Okay, so we can rely on this.
That is up to your lordship.
Officer HRD Chaudhary and Senior Counsel for the petitioner. None appears for the state. Next paragraph. It appears that the scanned copy of the LCR is available with the records of DA 2744 of 2022. Next paragraph, the Learned Senior Counsel for the petitioner submitted that in the meanwhile, few other witnesses have been examined. And a few witnesses have been examined.
Page 2811.
You know, you say 4 witnesses have been examined who do not implicate the petitioner. Learned AVP shall take note of the same. This is the matter in the this matter along with records of DA. So and so.
By almost
Mr.
9 months, madam.
9,
About 9 months they are enjoying.
9/6/2023. Okay. 9/6 will take it up.
Next item, we want only BA number will be different. madam. Your lordship's order is matter page 41.
Page 41. Here it will be record of 2779 of 2022. And Mr. Das is give us call for the APP, item 1 and 2. Okay, I'll inform the APP.
Anyone, if your
counsel.
lordship name anyone, he will inform my lordship.
Pardon me?
Anyone who normally comes, my lordship, he
No, it's
will
okay.
inform.
It's okay. I have passed an order, but
Fine.
still I'll inform the APP.
Fine.
I'll call him.
Obliged.
Huh.
Obliged.
6.
Yes.
In this case, I got the respondent number 7, my lord. The authority of the Kandiputi state, my lord.
You have been allotted land.
Yes, my lord. And
Where is the allotment letter?
my lord, here, lordship will find, my lord. Pattan Jamabandi we have enclosed here, my lord. That's annexure 1 and 2, my lord.
Page, give me the page.
Yes, I'm giving you. Page 17, you know, type copy, my lord. And original from 19 onwards, my lord. And Jamabandi mutation document also we have enclosed here, my lord. Annexure 3-4
Okay.
for the petition 1 through.
Mr. T.K. Ragavan, counsel for the petitioner. Yes. For revenue will be appearing. Miss P.R. Mahato, then standing counsel for the revenue department. Appearing for respondent numbers 1 and 2. And Mr. S. Barwar and a committee advocate appearing for the respondent numbers 3 to 6.
2 and 3, madam.
Okay, you have for 2 and 3. Okay, 2 and 3. And for 1, 4, 5 and 6. Besides, Barwa, government advocate. The petitioners claim that the entire land records under Musa Chandipur grant, Algapur in the district of Hailakandi are either tampered, misplaced or damaged under the custody of the official of the respondent authorities. Full stop. The petitioners also claim that they have that the land is their patta land and they are possessing since the time of their forefathers. And they apprehend that in collusion with the private respondent number 7, the land of the petitioners is sought to be converted into a tea garden land. And they also apprehend their eviction. Next, issue notice of motion returned within 4 weeks. Requisite extra copies of the revision deserved the state Department Council. Steps on respondent number 7. Heard both sides on the prayer for interim relief. Considering the projection that the petitioners hold patta in respect of the land in which they are occupying. Till the next return date, it is provided that the petitioners will not be evicted without due process of law. This are proposals.
Our one representation is pending before the deputy commission, maybe in the meantime.
Now they will not do anything.
Give the list.
Lordship, here petitioner husband mother died in COVID-19 measures. The government some issued some scheme under the chief minister's widow support scheme. As well as there are notification.
Issue notice. Okay. Had Mr.
M.R. Khandekar.
M.R. Khandekar and counsel for the petitioner. No, this is item number 7.
7.
No, 7 is not your matter. It's Mr. Udin's matter. I'll issue notice in this matter, Mr. Udin. But Mr. A.I. Udin and counsel for the petitioner. Officially, you will be appearing.
Yes.
And Mr. S. Barwal and the government advocate appearing for
All
the respondents. Issue notice of motion returnable in 4 weeks. Requisite extra copies of the petition to serve on the runner state and the government advocate in course of the day. Where is that letter 10/11/22? Where is that?
This is my letter, page 29. Annexure C.
So there's a new category of urgency. Huh? High Court urgent.
High Court urgent.
Very good. But there is a welcome move. Yes, a welcome move. But what happens to that
Nothing, my lord. That's
urgency?
what it was written on November,
That
but
extra punch didn't work. In fact, it is around November.
So what about the urgency? I think they want a travel concession to come to High Court. We'll call them. We'll satisfy them. Okay, in the meanwhile, the land government advocate shall obtain instructions as to the communication dated 10/11/2022 within bracket annexure 6. Okay.
Obliged.
That is also.
Yes.
My lord, I have agreed by my lord, annexer 3 at page 27.
Yes, okay, I'll be interfering. But Mr. P. Mountain and Counsel for the petitioner. And Mr. S. Barwal and the government advocate appearing for the respondents. Number 126.
6.
Issue notice of motion returnable within 4 weeks, requisite extra copies in course of the day. To the government advocate for respondent numbers 1 to 6. Petition shall take steps within 2 days for service of notice on respondents number 7 to 12 by registered post with AD. Permitted to collect postal visit number and 7 postal track report. Next paragraph. Heard both sides on the prayer for interim relief. It is projected in this case that by the impugn order dated 28/11/2022, the District Women Commission Nagaon issued a direction to the direction was to whom?
My lord,
No, to deduct money is direction to whom?
direction, my lord, to the authority concerned, my lord, the.
Which authority? Give me the name.
Superintendent of police, my lord.
To the Superintendent of Police Nagaon.
And subsequently that was deducted from the, my lord, my account by bank. My lord.
Acha. To deduct a sum of rupees 30,000 as monthly maintenance. To the petitioner's estranged wife. Namely Arifa Khatun within bracket respondent number 12. It is projected that pursuant to the said order, the said amount is being deducted from the bank account of the
For
petitioner
the last 5 months.
for the last 5 months. There is an amendment in the Mr. Barwa. Is there any amendment in the Women's Commission Act to allow them to adjudicate and pass orders? No.
No, my lord. After this judgment, my lord, this is the Bhavani Prasad Jana case. And the Honorable High Court also reiterating the same decision, my lord, the Prasanta Bhattacharya case. I have also relied in the, subsequently I filed the petition before the commission to recalling the order mentioned.
Just give me in 2 words.
My lord.
Just give me in 2 words. I am saying whether there is an amendment or not. Yes or no?
There is no amendment.
If I am taking up the full fledged hearing, but you see, I'll have to be short. Is it? I'll have to be short. I can't keep on hearing. So as the Women Commission is not bestowed with the power of adjudication, and the court is constrained to stay the operation of the order dated 28/11/2022 passed by the District Women Commission, Nagaon, in W/C within bracket N, case number 123 of 2022. Prospectively. The petitioners have produced a certified copy of the order before the Superintendent of Police, Nagaon. Whom?
Yes, ma'am.
Yes.
Superintendent of Police, Nagaon, as well as to
As
the,
well as the bank also.
as well as to the State Bank of India, Nagaon branch. Nagaon branch. Okay. List after 4 weeks. But take steps, otherwise I'll recall. Take steps, otherwise we'll recall the interim.
Today I will take this. Master question.
I would like to issue notice at this stage.
Heard. Mr. K. Chaudhary on the senior counsel, assisted by Mr. Har Dubey, the counsel for the petitioner. And Mr. M. Chedial and government advocate appearing for respondent numbers
1, 2, 3, my lord.
1, 2, and 3.
Yes.
Issue notice of motion returnable in 4 weeks. Requisite extra copies to the government advocate for respondent 1, 2, and 3. Petition shall take steps within 2 days for service of notice on respondent number 4 to 7 by registered post with AD. The counsel for the petitioner is permitted to collect postal receipt number and submit postal tax report prior to the next date of listing. Next column.
Pendency shall not be a bar to dispose of the.
Pendency of this requisition shall not be a bar for the which authority?
Chief Secretary, my lord. 100 pace at 5
No, we will not burden the chief secretary,
departmental secretary,
department secretary,
principal secretary of the department.
principal secretary of the principal secretary of the Department of Women and Children Development, within bracket respond number 2, to dispose of the representations of the petitioner dated
10/5/2023.
10/5/2023. Annexure
One second. Annexure 18.
18.
No, sorry, my lord. Annexure 28.
28. Okay. List of the petitioner is permitted to produce a certified copy of the order before the respondent number 2 to bring the order to the notice of the said authority.
Representation of copy.
And yes, unpaid bill,
Please, your lordship.
unpaid bill. Okay,
Lordship,
Uh,
the very outset,
unpaid bill.
the very outset, I did pardon because I could not, it was an inadvertent mistake on my part to leave the Deputy Commissioner Kokrajhar to be a party respondent. So may I be permitted to handwritten the name of
Okay,
the Deputy
you'll
Commissioner?
have to do it there.
Yes,
Will issue notice, Mr. Gogoi,
Lordship,
You are
the
appealing?
meantime they can implement.
you are appealing for?
I appear for the public works department. 1 and
PWD.
1 and 2.
1 and 2 will be for others. Just give me
But it
names.
will
The
be
Deputy Commissioner Kokrajhar. Lord.
3 and 4, he will
Achha.
appear.
Achha, and your name? Please come here. I must hear it.
Number 4.
P. Hazarika. P. Hazarika, Learned Government Learned Counsel, appearing on behalf of Mr. S.R. Rava, standing counsel for the BTC. Unpaid bill. Notice copies within the course of the day. Next para. As paid for by the counsel to the petitioner.
It's an admitted amount, Lordship.
No, it's okay, but I will
Yes.
issue notice. Make this first. The Learned Counsel of the petitioner submits that he may be permitted to include the Deputy Commissioner Kokrajhar
No.
as respondent number
5. Will be 5.
5.
Hi.
There is allowed, they said, including may be done in the presence of the registrar within bracket judicial. Pending impleading of the respondent number 5, issue notice. Next, but the pendency of the repetition shall not be a bar for the competent respondent authorities to examine the claim of the petitioner
Lordship.
and to make payment in
11
Please
also,
inform me.
Lordship, exactly same, Lordship, item number 11.
11 also same.
We have left out the Deputy Commissioner, Lordship. It was in the
Okay, okay. 10, 11. Okay. Well,
Deeply obliged, Lordship.
okay. I'll issue notice. Administer the will and counsel for the petitioner. And will be appearing for respondents. Which respondents?
Forest department, my lord.
I think I have not opened the brief. Forest. Yes, will be appearing for forest. Forest is Mr. Gowai. D. Gowai. Standing also for Forest Department, appearing for respondent numbers 1 and 2. For BTC, you will be appearing. Mr. Rava, you will be appearing for BTC.
Rita Bora was supposed to be.
Okay.
She is on
Okay.
the west and.
This is R. Borobora, then standing counsel for BTC appearing for respondent numbers 3 to 7. Issue You should notice a motion written within 3 weeks. Requisite extra copies of the resolution be served on the relevant state and departmental council in course of the day. Petition shall take steps within 2 days for service of notice on respond number 8 by registered post with AD. Next paragraph. It is provided that the where is this 16/3/23? Where is that?
So this is election of the notice notes. Annexure 9 lordship,
Page, give me the page.
73 lord. Is 73 and 74 lordship.
Then we'll have to dismiss your writ petition. That's why I thought something was there. This order you are challenging. Page 70,
Lordship, we have.
16/3/23, where is that letter?
Lordship, page number 20,
Page
lordship, there is a
23 or-
notice, lordship, they will not fulfill the category.
Which,
of
where is the
notice,
page?
lordship.
Which page?
Lordship,
16/3/23 is page 73, connection
Page
9.
73.
Yes, Lord.
no, lordship. The notice on page number 20, lordship. The notice was issued, lordship, for having a page of this context, lordship, they are not fulfilling the column of 12, lordship. We are challenging
Page,
Page 20, lordship, 20 to 23, lordship, the notice was issued, lordship, for the approval of this tender, lordship. On 21, lordship, they are not fulfilled the paragraph number 12, lordship.
you see, the difficulty is that I'm asking you something, you are replying something. It doesn't take you anywhere and I am stuck in this place because I am to sit. I can't move out. You will have the pleasure of moving out. If you don't like the court, you can just move out. But I can't do that. I have third time I've asked you 16/3. Mr. Gogoi has given the reply and you are taking me to a different page. That is not I am asking you. First, you have to listen to me if you want some positive order from the court. If I'm asking you something, please give a pinpointed reply. Correct? Otherwise, I have even read this Mahabharata, one of the largest epics. No story is bigger than that. I have read that book. If I have to, I can read that. Please be concise. I am asking a question for some bigger purpose. You see, out of so many documents, I have choose one document and I have asked you only one. I did not ask you about anything else. Correct?
Right.
So there is a purpose for it. If you take me here and there, it doesn't take you anywhere. Because I am stuck here.
I'm sorry, lordship.
No. Mr. Gogoi, what is the system? After the approval, what happens?
After the approval, your lordship, the person who is selected as a bidder, he has to apply for the environmental clearance certificate, your lordship.
Environment clearance certificate.
Yes, you know, go for environmental clearance. Thereafter, when he receives the environmental clearance, thereafter he has to go and sign agreement with the DFO. Thereafter, LOA is issued.
Okay. It is provided that the order of approval dated 16/3/2023 within bracket annexure 9 shall be subject to further orders that will be passed on the next date. Okay. That will be subject to orders on the next date. In the meantime, you file your reply. Now you got it, why I am wanting that. You understood? Why I wanted that letter only.
All right, Lord.
13.
I'll be issuing a notice here. This beneficiary list shall be subject to further orders that may be passed on the next date. When the petitioner says that he is entitled to petitioners. Her Mr. S. Islam and counsel for the petitioner. And Mr. M. Chetir and government advocate appearing for the respondent numbers
4 and 5.
4 and 5. And your name? S. Bora. N. Bora. 1, 2. 1367. Issue notice of motion returnable in 4 weeks. Requisite extra copies of the registration which are on the state and department council in course of the day. Steps in 2 days for service of notice and respond number 6-7 by registered post with AD, as well as by way of Dasti by routing the process to the registry of the court. And upon service, an affidavit of service shall be filed. Next paragraph is notice on the prayer for interim relief. It is provided that the beneficiary list dated 6/2/2023. Where is that page number?
It is not here, Lordship. I have not found where, applied for certificate copy. They have not provided, RT application is there.
Oh, okay, shall be subject to further orders that will be passed on the next date. We find out the next para, the learned who will be obtaining this select list 6/2/23. Who can obtain that?
Panel is prepared by deputy commissioner, as per guidance.
Deputy Commissioner. Oh, okay, the government advocate shall obtain the list of beneficiary that is 6/2/2023 prepared by the circle officer Bharpeta in respect of number 6 number Radha Kushi RADHA KUCHI Gaon Panchayat under Orunodoy scheme ORUNODOI scheme. And when you write letters, you tell them that what you call the reasons why the petitioner was not selected. This lot of points. Actually, you are there. In these two matters, we'll take it up on 9th. Nobody was here. Correct. You record his name. Mr.
Both of them, minor.
Abhidyut Sharma.
Minor.
Okay.
14.
Yes. Only with regard to stay.
Hello.
Only we got to pay for stay.
It means that only when the Supreme Court decided the issue, the excise duty which was refunded on the basis of the interim order passed by the Supreme Court, they had become payable. Now, can it be said, my lord, that the day when the payment was made, it became due, because till the judgment was delivered, the amount has not become due. And there is direct decision of the apex court, my lord, on the issue in the relating to the sales tax, where they said no. The day the Supreme Court decided the issue, after that only it became payable, and then only when the notice is issued, then the amount is payable. And if there is any delay, the interest will be chargeable. But not from the date, my lord.
But we have a judgment of this court. I couldn't find it yesterday. I couldn't do it. There was there was a time when in 96, all the electricity tariff were challenged. Enhancement of electricity duties were challenged. In that, there was a judgment of Honorable Justice J.N. Sharma, where when the validity of the enhanced charges was upheld for all these industries, they were asked to pay the amount
So
with
that was
dues.
similar because the validity of what was challenged before the High Court. And the High Court in the interim only directed the amount, certain amount to be stayed. And thereafter the amount became payable. Here, my lord, the only single judge stepped down. The division bench appealed, the writ appeal was dismissed. The matter went to the apex court. And the apex court stated the operation of the judgment only subject to payment of certain amount. Now, after the judgment was delivered by the apex court, final judgment was delivered, then only the amount become payable. In your lordship, I understand, the electricity case, the validity itself was before the, the challenge before the High Court. And in the interim, the High Court has not decided about validity. In the interim, certain directions were payable, like in the sales tax, your lordships, or any taxation, the petitions are filed. The lordship passes an interim order. The petition fails. The interest will be payable. There is no dispute about it. But here, this is not the case.
Just show me the decision.
My lord, your lordship.
Oh, Mr. Kyal, there was a matter which I was supposed to pass an order today,
Yes,
tax matter.
that has not been stated.
I was stuck with one issue.
Yes.
Therefore, I could not make up my mind. You see, in that case also, what I find is that the item which was for which tax demand is being made. Just
No,
verify it.
Well,
You may sit down and.
like I can also. have the
That
advantage
notification,
of-
regarding that Home Ministry notification.
Yes, there you see, what I find is that I've searched and I found out that it is in the exempted list. Correct. Now the petitioner, he is otherwise not liable to be taxed. The mistake he made was that I found out from several other judgments I've read. The requirement is that if there is a exemption out of say for an amount, 1 rupee is an exempt item. So when I'm filing a return, the assessee is required to disclose 100 rupees and then say 1 rupees is exempted and therefore taxable liability would be on 99. Correct. In that case, he does not do that. He does not disclose as a income exempt from taxation. And therefore, the sale tax authorities, they take the data from the AS-26 and then they find that there's a mismatch of the gross income.
Yes.
Gross receipts. That's a mismatch. But that is a mistake. Apparently, it appears to be a mistake. Now, the petitioner did not make a case where he admits that he has made a mistake. He is now contesting the matter otherwise on merit.
Yeah.
Correct. But ultimately, you see, it's the government which is for the people. Correct. So the government, can the government be permitted to make a profit out of somebody's mistake?
Here there's a provision for appeal. They could.
No, appeal is something else. I'm not on that. Power of appeal, I'm not there. But I was trying to find out. You see,
Definitely not.
because the revenue, otherwise also the government will not be entitled to because it's an exempt.
Definitely not. That I may agree.
Because
Let's see what if in
after some time I'm taking up tax matters again, so I've lost the touch with the GST and all. But I was trying to, 2 days, I was trying to make some research with the limited time I was having. But I found out that otherwise the item is exempted from taxation. So what the assessee did but a mistake. He did not admit that he does a mistake. Perhaps his lawyer did not advise him. And therefore he is contesting the matter. And all whatever it was argued was is an unacceptable argument. But if but the main point is that if the item is otherwise exempt from taxation,
If it is otherwise exempt, lordship, we cannot pay less tax. That is admitted.
so therefore I wanted to clear the doubt from you and therefore I withhold this passing of the order. Because can the government profit out of somebody's
No,
negligence?
definitely.
No, that's only the clarification I wanted.
Got
Interest on tax due,
Well, also we see para 11, Milord.
para 11.
I know. Facts of this case show that after the judgment of this court, the respondent state issued demand notice that is so and so specifically stating as follows. The Honorable Supreme Court of India has disposed of the civil appeal number so and so, and copy of the order has been sent to us after the disposal of the civil appeal. Tax on levy rise and on solid is possible. As per the statement submitted by you and report of the office, following amount of so and so is payable by you. From the above extract of the demand notice issued, it is clear that the fair demand notice was issued pursuant to the judgment of the court, which according to us is the right step taken pursuant to the declaration of the law by the court. The further question therefore is whether on the demands now made by the respondents on the appellant, the state can also claim interest. We have noticed that the power of the state to collect interest arises under section 959 of the act. The said section obliges the state to collect interest on belated payment of the tax demanded, but this payment of interest can be levied on such belated payment of tax which is legally payable, for which a valid demand is a condition precedent. As has been noticed by us, the demand notice for the years which was issued during the period when the state has no authority to levy tax, such that cannot be said to be a valid demand based on which such interest can be issued. A valid demand for the assessment year could have been made by the state of Haryana only after the judgment of the court from so and so, and on such a demand being made on so the appellant has satisfied the said demand within the period available to it. If that be so, in our opinion, the state could not have demanded interest on the tax due for the assessment services.
Okay, yes, Mr. K.
Lordship, here situation is something different. Lordship may come to page 139,
139.
paragraph 5. Whereas, being agreed with the judgment dated so of the division bench of Honorable Guwahati High Court, the Union of India file IA number so before the Honorable Supreme Court of India. The Honorable Supreme Court of India, by its interim order dated 7/12/2015, arising out of so passed by the High Court of Guwahati in the case of Union of India versus Kamakhya Cosmetic. The order is quoted. Pending further orders, we direct the subject to the petitioner releasing 50% of the amount due to the respondent in terms of impugned judgment on the respondent, furnishing solvent surety to the satisfaction of the jurisdictional commissioner. The operation of the impugned order shall remain stay. So 50% was directed to be paid subject to execution of solvent surety, lordship. In solvent surety, lordship, at present that has not been annexed. Whether with regard to interest and other thing has been mentioned or not. At this stage, I cannot tell. But that was subject to execution of the solvent surety, lordship. And when the judgment was passed, it was a solemn duty of the petitioner to restitute the amount to that respondent. When they failed, then notice was issued. So in my humble submission, lordship, they are entitled to interest from at least from the date of interim order passed by the Honorable Supreme Court.
Well, solvent security to ensure the realization of the amount, and that amount has already
No,
been
but
paid.
that solvency was never rejected because of
No, you see,
any defects. No.
Lordship, what happened? When the judgment was passed by the Honorable Supreme Court in 2002, April 2020. Lordship, since from the date, they were duty to refund the amount. When they failed to refund the amount, notice was issued. Even if that was not necessary. So in my humble submission, at least they are entitled, they are liable to pay interest from 7/12/2015.
If there is a full bench judgment of the Supreme Court, we'll have to examine it. So till the date of demand, you don't enforce the interest.
At least from the date of judgment, they are liable to pay.
So that's why
Yes.
till that date of judgment, you don't enforce that.
Lordship, we fix early date, lordship.
No, the date the so-called notice was issued, and after that, the 3 months time is there, and as per the 11A. Afterward, that whatever.
Whatever,
amount
till that, at least the date of judgment, they will not enforce interest.
Yes,
After that, we'll examine.
Now, because it will be difficult for them to calculate and all those things, if Rossip says only till the date of judgment, the calculation is not there. That what will the amount after the judgment and 3 months the notice. So I
No, you
think,
make your own calculation because
I think
calculation of
better
interest.
not if you Rossip for the time being, because that amount will be negligible for that. And if you Rossip in the team time, because ultimately we are ready to pay the interest from the date of the notice, 3 months. There is no dispute about it.
So it is only judgment and notice, 3
Notice,
months.
notice. It says below your Rossip see the.
It's okay, but still, till the date, at least to the date of judgment, because you have to protect the revenue also.
After the date of judgment, the notice has to come, because the demand has to be there, as section 11 AA also. And once the demand comes, then the time is there, within this time you have to make payment. After that, the amount will become due.
No, you see, you already have the X rupees of demand.
My lord.
Today, as on today, supposing there is a demand for extra amount of money. For that, you have already received a notice. So from,
They do no dispute with the amount, when the notice was issued. As per section 11A, there is a time period. Then within this period, amount has to be paid,
where is the notice?
you will also find it.
You see, therefore, you see, page 144 is 81 lakh rupees is the principal amount.
That has been paid, that has been paid.
Now interest is 52.65.
That has been calculated from the day when the interim order was passed and. the
No,
amount
that's
was
okay. That's okay. But here we'll say that till the date of that you make a calculation within 10 days and give it to him. Mr. Kyan,
paid.
you ask your authorities to make a calculation
Yes, we will.
from the date of judgment. Within 10 days, they will confirm.
Yes,
send it to you.
11A once,
11A
11AA.
of which
Central excise. Act.
Huh?
Central excise. Act.
central excise. See. Okay. Yes, 11AA.
Hello. Interest on delayed payment of duty.
Yes.
You also see the notwithstanding in the contained in the judgment order also. Tribunal of court or in any other provision of the act or the rules made there, the person who is liable to pay duty shall, in addition to duty, be liable to pay interest at the rate specified in subsection 2, whether such payment is made voluntarily or determination of the amount under subsection 11A. Interest at such rate not below 10% and not exceeding 30% per annum,
36.
2 million, section 2,
36%.
36%, I'm sorry. As the central government may by notification in the official gazette shall be paid, shall be paid in terms of section 11A, after the due date by the person liable to pay duty, and such interest shall be calculated from the date on which such duty becomes due up to the date of the actual payment of the amount due. Notwithstanding in the contained section 1, no interest is so. So, my lord, the amount will become due as per the, you also seen the Supreme Court judgment also, only on the demand notice having been made. So the demand notice having been made, that will be the date. So let them calculate the interest from that date.
It is only 2 or 3 months difference. That will adjudicate on the next date. We'll have the pleasure of hearing you again.
No, there's no problem for that. No. The question is only about the law which is there, otherwise, for 2 months.
No,
or 3
yeah,
months,
right. 2 or 3 months, but still.
you will also see the notice below 106.
I see the 100% demand equal to the tax due. That has also come.
106 million.
106.
Well,
Oh, acha. Yes.
the last paragraph of the notice was there. Therefore, as per section 11 of the Central Excise Act, you are hereby once again requested to pay the amount of refund sanction provisionally to you, while number so and so, issued by the Assistant Commissioner so and so, Divigad, in accordance with the interim order passed by the so and so, dated so and so, repeat so and so only. Only along with applicable interest within 15 days of the receipt of the letter. Otherwise, action may be initiated for recovery of the amount. Now you will also find the first date notice. You will also find first letter in the first page.
No, that they will not enforce.
The first letter.
That they will not enforce.
My
That they will not enforce
Amount have you paid? Only the amount is a question of the interest,
interest.
nothing below beyond that. So realization of the interest for the time being, Lord. And on the next date, they may place before lodging the calculation. I will have no problem.
They'll mail it to you. They'll mail it to you directly.
Yes, Lordship, that I will instruct my Lordship. I have another submission, Lordship, with regard to without arguing on the point whether it will be applicable from the interim order passed by the Supreme Court or from the date of judgment. Lordship, may I have given one judgment 2010 SEC page 734, paragraph 3, 4 and 3, 4, 5 and 6. Exactly same issue was there, Lordship.
Woodcraft products.
Yes, Lord. Paragraph 3. Short judgment.
The draft is about issuance of 11A notice, that amount. become
Correct.
payable.
This, what do you call, this supports the submission of Dr. Saraf.
Lordship.
This supports the, you see, in the first para 2. This court on 20 March 1995 reversed the tribunal's order.
Lordship.
On 22nd June and 26th August 95, the revenue called upon the SSC to repay the amount.
Yes, Lordship.
Correct.
Yeah.
And then in the paragraph you are showing, it says that the interest would be paid last para 6 from 1st September 95. That means,
Till the payment is.
The later judgment was reversed.
that means after the date of demand. So in fact,
No, Lordship, in this case, what happened, the tribunal reversed the order. So from the date of judgment, when it was reversed, it was their duty to refund its amount. There is
it's okay,
even
but you see what the Supreme Court has done.
yes, Lordship, paragraph 6.
22nd June and 26th August 95 demand was made by revenue, para 2,
Lordship.
correct? Para 2 last 4 lines, Woodcraft products, you have highlighted that.
Yes,
On 22nd June and 26th August 95, revenue called upon the SSC to prepay the amount which has been refunded as aforesaid.
yes.
Correct. Now come to para 6.
Lordship, paragraph 4 is also important.
No, it's okay.
Yes,
I am on the date. You see
Yes.
the date, they say 1st September 95.
September 95.
So that
Yes.
means it supports the argument of Dr. Saraf.
Then for interim, Lordship. In this case, what happened, Lordship, they executed a solemn surety in 7/12/1995, 2015 was. Judgment was passed on 20th of April 2020. So at least from the date of judgment. Till.
No, but
payment was
now you
made-
are showing us that from the date of demand.
No, Lordship, here, Lordship, make please to see, paragraph 4.
Yes, I have seen that.
The SEC obliged to make restitution.
Yes.
The revenue honored the tribunal's order and made the refund. Same thing he was here, we honored the honorable Supreme Court's order and. amount
But
was
still what the Supreme Court went ahead and did.
Upon the reversal of this court, the tribunal, the SEC was bound in law to restrict the amount of such refund of the revenue.
Well,
Now,
the dispute
there is a
will
with
end
regard
after
to
2 months.
with regard to dispute of that date, from which date they are liable to pay interest.
No, but you see, demand was made in 26th August 95, last demand. First demand was made on 22nd June. Second demand on 26th August 95 for restitution.
Yes.
Judgment of the Supreme Court was on 20 March 95. Before Woodcraft line. I've read it, that's what I'm telling you,
This
because
court,
this court on 20 March
Reversed.
95 reversed the tribunal's order. So judgment of the Supreme Court is 20 March. First demand is on 22nd June. Second demand is on 26th August 95. And Supreme Court says interest from 1 September.
After the
So it
issuance
is
of notice.
supporting Dr. Saraf's argument. I was giving you more.
No, Lordship, my point is, Lordship, when the judgment was reversed by the honorable Supreme Court, from at least from that date, they are required to restitute the amount to the department. Lordship.
That
Well,
is
at least-
okay.
At least it may be admitted that. it
That-
will
that is
be
okay,
at
but-
best be payable from the date of judgment, so they at least the.
No,
whether
the-
the
For interim,
dispute
Lordship,
will be
may-
limited.
for For interim lordship,
No, there is no question of entering the, my lord, if he says that at least it should be, so let them at least forego from prior to that, and then the only dispute.
No,
will
he
be-
can't say that.
No, no,
He's
not say-
assessing the court. He can't make an admission.
No, lordship, because this exhibit solvency, what is there, that is to be produced before the lordship.
No, it's, you see, otherwise your department would have rejected you. It's not a, it is not a proper solvent security. Your department would have rejected it. It would not have kept it.
No, lordship, my point is this, because there was an interim order of Honorable Supreme Court. On the basis of that, we refunded 50% the amount. And there was a further direction of the Supreme Court that this should be subject to execution of solvency by the petitioner of the department. And judgment was passed in 2020 April laws. When it was reversed, the order of the division bench was reversed. So from that date, it was their duty to refund the amount. When they didn't, then
Nobody is saying no. Even Supreme Court in this case you are citing doesn't say no.
yes, lordship,
Duty was there. But still it imposed interest only from 1 September.
but that was lordship,
Because
But I will,
you are bettering his case.
I submit the till the judgment of the apex court. This honorable court judgment remain.
No, it's
Whereby-
okay. I've got it. That much
My
time I got it. I'm giving that relief.
I'm
Uh,
grateful to
information
Mr.
will intimate to them.
I'm grateful to Mr. K.R. Millot for providing
Supporting you.
Further Millot
For supporting you.
materials, not supporting, but providing materials which goes in my favor.
Dr. Ashok Saraf, senior counsel assisted by Mr. N. Datta, counsel for the petitioner. And Mr. S. C. Kyal, then it's standing counsel for the respondents. Issue notice of motion returnable in 4 weeks. Requisite extra copies of the declaration is served on the Honorable Department counsel in course of the day. Next, heard both sides on the prayer for interim relief. First, the learned senior counsel for the petitioner. By referring to the case of Food Corporation of India versus State of Haryana and another, within bracket 2000, bracket close 3 SCC 495, has submitted that the principle that can be called out from the said decision is that the interest would have been validly claimed from the date of demand being made. The contention is opposed by the learned standing counsel for the respondents by submitting that as the challenge was negated by the Supreme Court of India by judgment and order dated. What is the date?
Telling me next will be the date,
Just give me the date.
204/2020.
204/2020, comma, it was the duty of the petitioner to deposit the to satisfy the demand regarding refund which was provided to the petitioner pursuant to the orders of the court. In this, in support of this contention, the learned standing counsel for the respondents has referred to the case of Commissioner of Central Excise, Shillong versus Woodcraft Products Limited, comma 2002. 10 SCC 734. So, on consideration of the matter in its entirety, as an interim measure, the court is inclined to provide that that taking note of the fact that the petitioner claims to have deposited the principal amount due on when
On 23rd March 2021.
23rd March 2021. Or the petitioner shall deposit interest claimed by the respondents from the date of
Notice 26/5/2020. At page 104.
20,
104 million.
just give me the date.
26/5/2020.
It is the first demand. And you paid the amount when?
26/3/2021.
And the date of judgment is
22/4/2020. 24/2020. It's only 1 month difference.
only 1 month difference.
That is only for future, laying down the law, that is. Here it is 1 month difference, sometimes maybe 6 months, so.
From 22/4/2020. PO2
The date of payment.
to 20 25/2020.
Yes, ma'am.
25/2020. 1 month only. How the insofar as the balance demand is concerned, same will be subject to further orders that may pass in the.
So I think you also mentioned the date, the payment was made on 26/3/2021.
26/3/21.
20.
Okay, so the date of judgment is
22/2020.
22 April 2020.
20th only.
Okay, 20
20.
April, okay. 20 April 2020, TO2, 26/3/2021. So however, the said payment shall be subject to further orders that may be passed on the next date. First of all, it is also provided that the department and the respondent shall calculate the interest and intimate to the petitioner by email. You have the address,
We are agreed with it.
this within 10 days from
Within
today,
10 days.
and payment shall be made within a week thereafter.
Not until then, will after payment, the payment such but the balance demand is administered. Balance demand on interest. On payment of such amount,
Pardon me,
on payment of such amount will not determine the balance interest demand shall remain state.
sir. On payment of the such said amount, the balance demand for interest shall remain stable.
Right, much. I'm obliged.
Mr. Chaudhary, no, you can sit there, no problem. The initial grooming since childhood is to first lay claim on the interest, not the principal. Let the principal remain. You'll take all efforts to get the interest first. When Dr. Saraf was arguing, I was remembering my young days when this was the grooming.
Interest for deducted in advance.
Yes, at times, yes, you are right. The elderly people in our community, elderly people, when we visit our friend and even in the road, when they catch us, they give some tips. There were many elderly people who loved us. And so just they will call and give us some tips. But now I find that that was the bridge in the society, which was making us respect the elders. And that gap, age gap was not there. At times in the community, that age gaps were not there. And I still remember in few friends, there were elderly ladies or elderly people in the house. Anybody walking on the road, they will catch and then ask them, who are you, where you are going? So even in villages, everybody would, an unknown person loitering would be called and then asked and then go, and then the bondings remain. Who the neighbors are. Yes, Mr. Bharali. Oh, sorry, Mr. Das. Yes.
What has happened in this case is Lordship, on mutation case has been proceeded with, in which we were asked to appear. We appeared to our council. Now I'm the.
You have to give copies. Documents you are not providing.
That is my limited privilege.
Well, it will be provided, but another repetition, my lord. There is a family dispute between the,
I understand.
the brother filed another repetition, my lord. In that case, my lord, court asks us to whether what is the action taken. So we have issued notice to all of them, my lord, to appear before us, my lord.
Okay,
On the basis of the High Court's order, we have passed the order.
okay.
And lordship, we have take it with the other item, my lord, WPC number, my lord, 1829/2023.
Okay.
Private respondent filed a
In
repetition.
that case, whether it is a bar.
Oh, yeah, my lord, he is.
Oh, sir. Good.
Lordship, in the earlier case, in fact, we are not made parties in that repetition. I annexed the order, we were not made parties in that repetition. And yes, Lordship, my limited prayer for the day is, Lordship, they may submit us the copies of the application which has been filed and give us the opportunity to file our written objection. And thereafter
Yes.
proceed in accordance.
Against, this is against Apurva Vallabh Goswami.
Yes, my lord, the other matter that were filed, because my lord, the partition cases were filed, there no action was taken for a very long time. That's why we approached this honorable.
No, that is okay.
That matter is fixed on 7th,
But he received a notice of that partition case.
my lord.
And the deputy commissioner is not providing, the revenue secretary is not providing with any document.
So all the documents are there in my repetition.
In the repetition, all those documents are there.
Lordship, that repetition, we were
document?
not made parties.
Sir,
My
petition, yeah, in the repetition filed by the private respondent.
He will not have a copy of that. He is not a
Lordship, I have
party
not
there.
even made a party in that. He's a party there.
He is not a party there.
So he will not have it.
So let both the matters come, my lord, I'll provide him all the.
Lordship, the next date is fixed on 15/6.
15/6.
Lordship.
Okay.
The matter is fixed on 7th, my lord, my. repetition is
Okay.
fixed on 7th.
Can I,
Otherwise, we are not.
can I record your, your presence through your instructing counsel?
Your lordship may, my lord, I'll get the.
Lordship, Lordship, in that case, the repetition has been filed saying that the mutation case has not been proceeded with. We are not objecting to proceedings in the mutation case, Lordship, but the only thing is that the principle of natural justice has to be followed. That is why this repetition has been filed.
It's okay. It's okay. At this time, Das Leonard, counsel for the petitioner, and Mr. J. Sutia Leonard, standing counsel for the Karbi Anglong Autonomous Council, appearing for respondent numbers 1 to 5. At the outset, the learned standing counsel for the respondent numbers 1 to 5 has submitted that the issue involved in this writ petition is also raised, is also connected with the issue raised in WPC
1829 of 20.
1829 of 2023. Full stop. Incidentally, the learned senior counsel, who is representing the respondent number, who's representing the petitioner in this said writ petition, is present in court today. Along with Mr. P. Bharadwaj, his instructing counsel. First of the petitioner in this said writ petition is the respondent number 6 in this writ petition. First of, as the interest of the respondent number 6 is involved in the said writ petition, at the instance of the court, the learned senior counsel for the writ petition in this said writ petition has been heard on behalf of respondent number 6 in this writ petition. With subject to his subject to appearance of his instructing counsel on the strength of Wakalatnama to be submitted.
Right.
Because I can't compel you to appear here. That's why. Next paragraph. The grievance of the petitioner is that he has been served with a partition notice. A notice in a partition proceedings. Where the date of appearance is fixed on 15/6/2023 before the
Joint Secretary.
Joint Secretary
CALA, Department of Revenue, Karbi Anglong Autonomous Council.
in charge CALA, Department of Revenue, Karbi Anglong Autonomous Council, which is filed by the respondent number 6 herein. So it is projected that the petitioner had approached the the Joint Secretary Kala is respondent number 4. The respondent number 4 for documents which was not furnished. So it is submitted that without knowing the documents based on which the partition proceeding was instituted, the petitioner would suffer prejudice. Hence, he has approached this court by filing this writ petition under Article 226 of the Constitution of India, claiming direction upon the respondent number 4 for providing him with a copy of documents relating to the said partition proceeding. Next, I issue notice of motion returnable on. What is the date then? 7/6/2023. Requisite extra copies of the writ petition be served on the learned departmental counsel for respondent numbers 1 to 5 and to the learned instructing counsel for respondent number 6. Next, the pendency of this writ petition shall not be a bar for the respondent number 6 and or the respondent number 4 to provide a copy of the documents based on which partition proceedings have been instituted to the learned counsel for the petitioner and or to the petitioner. list on 7/6/2023 along with WPC 1829/2023.
Lordship, mayor, the mayor for interim will be considered on that day if the matter is not taken.
Oh, okay, notice including notice in the paper interview.
Lordship.
Okay.
Obliged, Lordship.
I said, just a moment, I forgot something. As respondent number 6 has entered appearance, issuance of formal postal steps is exempted.
Lordship, notice will go to respondent number 7, Lordship. Notice has to go to respondent number 7. Lordship.
Who is 7?
7 is the joint secretary. He has been made party by me.
No, we'll date his name. I did not notice that, 7.
By name, to say.
No, we'll reject that.
name.
No. We'll delete him unnecessarily.
You'll not,
It is noted that the respondent number 4 is also iterated by name. Full stop. As the court has already issued a direction to the respondent number 6 and to respondent number 4 to provide copies, the court is of the considered opinion that the including of respondent number 4 by name would not be. No, 4 by name as respondent number 7 may not be necessary, and therefore the name of respondent number 7, who is the officer implicated by name, is deleted. Let the order be brought to the notice of the Registrar Judicial to make necessary correction in the central registry. List once mentioned.
16.
Ahmed, please.
Your amount is withheld.
Yes, your lordship, right.
Okay, I heard Mr. D. Senapati, learned counsel for the petitioner. Ms.
BL Singh.
B.N. Singh, learned,
Appearing for
standing counsel for respondent number
2, 3, and 4, NHIDCL.
2, 3, and 4, within bracket NHIDCL. CGC will be appearing. Mr. Gogoi, Transport Ministry. Mr. K. Gogoi, learned CGC, appearing for respondent number 1. Issue notice return within 4 weeks. Requisite extra copies of the petition be served on the learned CGC and departmental counsel for respondent numbers 1 to 4. So the petitioner shall take steps for service of notice on respondent numbers. Steps within 2 days for service of notice on respondent number 5 and 6. That is procedure D. Counsel for the petitioner is permitted to collect the postal list number and submit postal track report prior to the next date of listing. Next paragraph. The pendency of this petition is not, shall not be a bar for the respondent number
2 and 3.
2 and 3 to examine the.
Lordship, because there is no agreement between 2 and 3 and the
We are just
petitioner.
asking you to examine it.
So the direction may kindly not be given to respondent 2, 3, and 4.
No, they can reject it.
Lordship. Only
can reject it.
representation has been filed to the department only because they have no
No, I
knowledge.
understand, but if they don't have knowledge, they will reject it.
Lordship.
But it will not be a bar for them to consider it. Not be a bar to consider the representation dated
12/5/2023.
12/5/2023 within bracket annexure 7.
Page 47.
Okay. They can examine it. In fact. They may reject it, that's different matter, but this helps to early negotiation between the parties.
4 weeks. Lots of friends.
18.
Normally in a department, Mrs. Singh, nothing happens without knowing. Correct. Yes, I'll issue a notice.
Yes.
That Mr. N.J. Barwal and counsel for the petitioner. And Mr. K. Gogoi Leonard,
I am for the respondent.
additional senior government advocate appearing for respondent numbers.
2, 3, 2 and 3 also.
One also, Acha, one will be revenue.
Revenue.
Okay, 2 and 3, Mrs. G. Hazarika, standing also for revenue department for respondent number 1.
Petitioner claiming lordship from
Non-payment of bill.
87 2011 to lordship 37 2014 lordship.
I'm not saying anything right now.
Lordship.
We're claiming non-payment of bill. The petitions in file under Article 226. Notice. Extra coverage within course of the day. Pendency shall not be a bar for the responding authorities to examine the claim of the petitioner and to
Lordship.
disburse money found due.
Lordship,
Yes.
our name may be reflected in the contest.
Okay, okay. The registry shall reflect the name of SC Revenue while listing the matter next.
We have that.
19. Bed with the lordship.
Okay. I'll issue notice. The pendency shall not be a bar to bring it to logical conclusion.
Yes, that they will consider it. Only thing is, my lord, for the last 4 months, neither they're disposing they're taking the so-called notice to any logical end. At the same time, my lord, my vehicle is not being deployed.
I understand, I've seen that.
Or lordship can dispose of with the direction.
Disposal, Mr. Chaudhary, gives difficulty. I mean, I am of the view that.
Tendency will not be a bar to.
Because it leads to contamination, again, it leads to
Right,
second round of
right,
litigation.
Tendency will not be a bar to take the so-called
In-
notice
in-
to logical end.
The initial stages I did it, but I found that I am some orders come back.
Well, on merit, I was just thinking, prima facie, my lord, these so-called violations are not even attractive. Anyway, that they will deal, my lord.
No, but apparently you have a case. No, not.
And my lord, they will also consider giving me work, my lord. After end of the day, I am a businessman, my lord. I've taken loan to procure that vehicle. I'm paying interest without any.
That I will not mention it now. Uh, Mr. K. Chaudhary, Rana, senior counsel, assistant one Shay Das, and counsel for the petitioners. And Mr. P. Bharadas, done study notes for the respondents. Issue notice of motion returned within 4 weeks. Requisite extra copies of the petition be served on the counsel for the respondents in course of the day. Next para. Having regard to the nature of dispute raised in this issue raised in this rate petition, for the court is intent to provide that the pendency of this rate petition shall not be a bar for the respondent number.
1 second, my lord, the deputy general manager operations.
Okay, the deputy general manager operations within bracket respondent number 3
Yes, my lord.
to bring the show cause notice issued to the petitioner to its logical conclusion. Next para. The learned counsel for the respondent shall transmit a copy of the or downloaded copy of this order to the respondent number 3 to bring the order to his notice. This
Yes,
this happened for weeks.
Okay.
But he's right, Mr. Bharadwaj. Nobody wants to miss out business.
That's what I was informed today morning by telephone. That this, we are going over the entire.
Small things should not come in the way.
20.
May it pleases the Lordship. Lordship, the petitioners are landowners whose land has been used to construct overhead transmission line over the residential houses of the petitioners Lordship. And till date, no compensation has been paid Lordship. Individual representations were submitted by the petitioners Lordship before the respondent number 6, but no redressal.
Okay. But Mr.
Zaman Lordship.
Zaman, then counsel for the petitioner. Miss, M. Burman.
I'm K. Fukan, your
Okay,
lordship.
Mr. K. Fukan, I'm sorry, I forget.
Yes.
Growing old. Okay, Mr. K.
No, your
Fukan, then counsel for the
Respondent number 1, 2, and 3 for age.
number 1, 2, and 3. For revenue, you will be there, Ms. G. Hazarika, and standing person for revenue. Respondent number, revenues. Okay, you leave for 1 to 4. For 1 to 4, my revenues for
1, 2,
5.
and 3. 1, 2, and 3, your lordship.
No, 4 also,
4
assistant.
is power department, state of Assam.
Oh, so you're not appealing for power.
4 and 6, I will.
4 and 6, you will be there. Mr. K. Govil and additional senior committee advocate appealing for respondent number 4 and 6. If you notice the motion returnable in 4 weeks. Revisit extra copies of the revision is served on the state and departmental council in course of the day. Next paragraph. The pendency of this writ petition shall not be barred for the Deputy Commissioner Gwalpara within bracket respondent number 6. To examine the claim of the petitioner for compensation. Where is the right of way notification?
Lordship, at page 28, that guideline issued by the government.
No. There must be acquisition notification. Page 37.
37. Lord.
No. Where is the notification by acquisition? Where is that? Right of way, where is that order of right of way?
Page 37 is the notification published in Assam Gazette regarding right of way.
No, your land is taken away from on basis of what notification?
Lordship, one provisional notice was issued to the.
Where is that?
Page 27, Lordship.
27.
27. Notice was issued to the petitioner number 1 only.
Pursuant to notice dated 16/3/2022 within bracket annexure 2. Provisional notice dated 16/3/2022 annexure 2. No. No, not this. Right of way must be determined. Where is that document? Can you find out?
Deputy Commissioner.
That document is not.
By Deputy Commissioner, your lordship.
Yes, where is that? The right of way must be determined. They'll not be able to find out unless you tell us the facts.
Lordship, that document is not available. This provisional notice is issued to.
No,
the
this notice, you see, that means you have not done the homework. This notice is merely a direction by the APTCL to take over that area. The right of way is always ordered by the Deputy Commissioner.
We have not received anything.
You will not receive it. You'll have to collect it. Mr. Fukan, what is the meaning of this page 27, nota bene? What is that? What do you understand from it?
My lord, here it is written that the said line passes through your land noted below lordship, and the land description was given below, my lord. Name of the landowner, the petitioner number 1 here, lordship.
You had to ask them for a right of way. Ms. Fukan,
Yes, your lordship.
come to page 27.
Yes, your lordship.
In the bottom is a nota bene, and this letter has been interpolated from signature of, what does it mean?
AGCL, Assistant General Manager.
No, no, this letter has been interpolated from the signature. Interpolation means tampered.
Interpolated from the signature of AGCL provision and notice to contract and
Interpolated means what? I give an order,
yes,
somebody interpolates the order. I reject bail, he says that bail is granted. That is interpolation.
yes, your
Now, how does the APDCL interpolate the letter and give it?
lordship.
Somebody has to go to school back. Is it not?
Yes, your lordship.
Now, who should be sent to school again?
Yes, I have been transferred.
But you give him, assist him. To examine the claim of the petitioner for compensation. On construction, on the setting up of transmission, high voltage transmission line to the land of the petitioner. You collect information, give it to him, otherwise he will not be, nothing will happen in this matter.
Yes, your lordship.
Correct. Seek our assistance and get the information.
Yes, your lordship.
Yes, lordship.
We can give you one.
We will require health.
Time for respondent number 3 in this.
Respondent number 3 is the principal secretary. I think your response will be required more.
Your lordship, the petitioner has, petitioner's prayer is to grant permission.
Yes, that has to be considered by you. You see, age has got nothing, my understanding is, age has got nothing to do with
Yes.
this. It's a fundamental right.
Yes, lordship.
And if you go by the principles of Hindu law, then it's a duty of the couple to procreate. Correct.
Lordship may take up it after some time, lordship, the council, central government, they here.
Okay. Okay, age is nothing.
Age is nothing.
We have an example in Mizoram. You understand what I'm referring to? In Mizoram, there is a world's largest family residing in a village in Mizoram.
Lordship.
Okay, after some time.
After some time, lordship.
Yes, okay.
Your presence is
22.
necessary.
Okay, Bill.
Yes, lordship.
Okay. S.A. Ahmed for the petitioner. You are appearing,
Sir.
Miss
And Bora.
and Bora for the responding numbers.
Respondent number 1, 2, 3, 4, and 5.
1, 2, 3, 4, and 5. Anybody else you are appearing?
I'm for respondent number 6.
I'm sitting for respondent number 3. Unpaid bills. You should notice pendency should not be a bar. steps in course of the day. You will give extra copies.
23.
Bill. Same bill, Mr. D. Chaudhary. D. Yes. For the petitioner. Your name
Yes, Guru, on behalf of RB Bora.
is S. Borua. S. Boro. On behalf of Ms. RB Bora, standing counsel for BTC. Unpaid bills, same. Pendency shall not be above.
IPF for 6.
Yes, you're there. Will issue a notice?
Yes.
You're for?
Respondent number 6.
I said respondent number 6, Mr.
Finance.
Big away, respondent number 6. Okay. Huh? 21, we can take it up?
Yes.
21.
You'll be appearing, Mr. Gogoi, in this matter, 21? Then who was to appear? Huh? Oh, acha, Mr. Gogoi, acha, I thought, okay. Okay,
24.
same bill,
That's the same.
okay, same, okay, same.
25.
Here, item 23, 20%.
25.
Yeah, Mr. Rusty.
Yes, you are appearing.
Please proceed.
But this is a disputed question of fact. How can the High Court decide?
Yes, sir.
Rusty, Rusty,
You
kindly
see,
come-
somebody has been empaneled,
Yes, Rusty.
correct? Now, the basis of empanelment, let us say that your company, principal company has appointed them.
Yes.
They are appointed you also, they appointed them. How can we decide in the writ petition?
Rusty, I am the authorized dealer. I am the authorized dealer of.
No, that is okay. You say that you are the authorized dealer.
I have the, Rusty, kindly come to page 26, Rusty, and except for.
Page 26. Yes,
Rusty, is, for reference number 2.
this I've read. You see, second line, you will make it clear. Certify that UD Scientific is one of our authorized dealer.
Yes, Rusty.
It doesn't say that you are the only dealer.
Lordship, in this particular notification, Lordship, I am the only authorized dealer. Lordship, kindly come to page 12, Lordship. And in the 12,
You see,
Lordship, and in the 12,
no. You see, your empanelment, this present procurement is done when their empanelment list is this annexure 9,
yes, Lordship.
right? 29/4/2023.
Yes, Lordship.
You are making me read page 26.
Yes, Lordship.
Now look at page 26, reference number so and so dated 2/2/2022. Correct? In the third paragraph, it says, this authorization certificate is valid up to the rate contract period.
Yes, Lordship. Lordship, for this particular notification, I am authorized dealer, Lordship. I am the only authorized dealer for this particular notification, Lordship. Kindly come to page annexure 12. Page, Lordship, 65, Lordship.
You see, I don't know, I can't be convinced. Come to page 50 again.
Lordship,
I'll show you that this will mean that I have read something. Page 50. Pursuant to NIT published by advertisement number so and so dated 22/2022, right? Page 50.
yes, Lordship, 50.
Correct. First line. NIT dated so and so dated 2/2/2022
Yes, Lordship.
and re-advertisement dated 4/5/2022.
Yes, Lordship.
This authorization letter is only for 2/2/2022. It has expired.
No, Lordship. Lordship, kindly come to page 67, Lordship.
Page 60.
67.
Seven.
Lordship, as another, Lordship 65 Lordship, page 65.
Page
65 Lordship.
65.
Lordship. May I read the second paragraph? This is to bring to your kind consideration that no valid authorization was issued from our end to MS Krishna Enterprise for this
Okay, then
particular
I'll issue
tender.
notice, Mr. Gogoi.
Lordship.
Then I'll issue notice to you. Heard Miss K. Malakar,
Yes, Lordship.
counsel for the petitioners, and Mr. R. R. Gogoi, learned standing counsel for the respondents. Number,
For 1 year, Lordship.
respondent number 1. Issue notice of motion returnable in 4 weeks. Requisite extra copies of the petition be served on the running counsel for respondent number 1 in course of the day. Next paragraph, petition shall take steps within 2 days for service of notice on the respondent numbers 2 and 3 by registered post with AD. So the learned counsel of the petitioner is at liberty to collect the postal receipt number and submit postal track report prior to the next date of listing. Next paragraph. The learned counsel for the petitioner has referred to page 65 of the writ petition. Project that the petitioner is an authorized dealer of a company named Genetic, GENETIX Biotech, BIOTECH Asia, ASIA, within bracket T, private brackets, the limited LTD for tender wide advertisement dated 2/2/2022 and re-advertisement dated 4/5/2022. And accordingly, where is your representation?
My Lordship, and itself. And it's a 14 Lordship.
Please give me the page number.
67 Lordship,
Page
67.
is 67. And accordingly, my representation at page 67 of the writ petition, the petitioner has requested the registrar, Assam University, Assam Agriculture University, within bracket respondent number 1. Yeah, panel. Their name is their name is their name in the rate, the name is supplier for chemicals and glassware. Dependency of the reputation shall not be barred for the respondent 1 to examine the claim of the petitioner. To consider the representation of the petitioner at page 67 of the writ petition and pass appropriate orders. List out of 4 weeks.
Advocate.
26.
Just a moment, the petitioner is permitted to serve a certified copy of this order to the respondent 1 to bring the order to the notice of the said authority. Yes, 26, unpaid bill. Okay, your name? B. Malakar, okay. the Malaga for the petition, unpaid bills, Mr. D. Gogoi for the, for all the respondents,
My 2, 3 and 4.
2, 3,
One
and
will
4.
be government.
One will be,
One will be government.
Mr.
No, I'm not.
M. Shetty, government for.
Really, my lord, chief secretary is not a necessary party otherwise. It's non-payment of contractual bill. Chief secretary has no role in this.
I know, but.
2,
Pendency
3,
shall not
4
be
may
allowed.
be issued, my lord. 2, 3, 4, my lord. Notice may be issued to 2, 3 and 4. One is not.
Achha,
necessary.
notice on 2, 3 and
Yeah,
4.
only
only.
2, 3.
Notice on 2, 3 and 4. Pendency shall not be a bar.
Obligation.
27.
Just add one more line. At this stage, the notice is not issued on respondent 1. Yes. Oh, that, appraisal matter, okay.
Similar to
Ah.
can be passed.
Ah,
Only one mistake is there, actually, in the first paragraph, you just mentioned that we have approached the learning edition study. Actually, we have not approached my law. We landowner originally approached the learning edition difficulty. That the first paragraph, there may be some correction, my lord.
Krishna is agree with the different information. Okay, I have made the correction. I'm just speaking it out.
I didn't meet a
my
lord.
The petitioner is agreed by the determination of compensation for drawing overhead electricity transmission line.
Right.
The landowners had approached the court of learned additional district judge so and so under 16, and the said learned court had passed the impugn order. Then para 3.
Well,
What is the correction in para 3?
as per the provisions of subsection 5 of section, it should be 16, well, not 15. Well.
Okay, 16.
Okay. Yeah, but others are certain. There is any mistake. Well.
It's okay.
Well,
Para 5 is not required.
no, madam.
6 is also not required.
No, madam.
Para 1, 2, 3, 4 is here. Next, para 5. Issue notice of motion returnable in 4 weeks.
Well. No, but we have this, the petition is to be converted to a joint petition, madam. As per that example.
No, now it is writ petition.
My lord, it should be under article 227, my lord. There is a direction issued by your lordship, my lord. It should be registered as a civil division, my lord, not as a petition, my lord.
No. Oh, okay.
This new case, but this the petition, my lord. New petition, my lord.
Oh, this is a new petition.
New petition,
Oh, okay. I thought it came after correction.
My lord.
Oh, okay. I was under misconception.
My lord.
Having seen this matter, I thought that it was
Okay.
correct. Oh, okay. So 5 and 6 will be required.
My lord.
Sorry, 5 and 6 will be required. Okay.
Only my lord, they correction in the first page and they in a paragraph
okay,
3
okay.
of the section, my lord.
No, it's okay. I was striking out 5 and 6 because I was issuing a notice. Okay. Rest will be same. Yes, just, one second. Okay.
The item
There are two more items. Two more items are there,
Item of 29, my lord,
29,
29.
okay. Similar,
Always to lord. 29.
okay. 29 gone. 29 also, same order. Yes, Sarfasi, again, you have the earlier order. Give the copy.
The private expense may be stuck.
Okay. You want to say A Dhanuka? Just change the name here, A Dhanuka. And Mr. M. Chetia for respondent numbers, government advocate appearing for respondent numbers 1, 2, and 3, and 4 also. Here, issue notice on respondent numbers 5, 6, and 7 by registered post with AD. The constable of the petitioner is permitted to collect the postal receipt number and submit postal track report prior to the next day to receipt. Just add here and then same order. This will be added in para, after para. After para 4. Same order. This time sitting for the government advocate. 1, 2, 3. Okay.
RT. May please, your lord.
Yes.
Well, this matter relates to the non-release of fertilizer of the petitioner by the police authority of Hailakandi. Particularly, my lord,
You see, Zimmer petition we can't entertain. If
My lord,
they,
the petition was allowed and directed to release the petitioner.
you see,
appeared
the court who is passing an order is not, has the competence to enforce its order. Or if they are not doing it, then you have to come in contempt. You see, you get a Zimmer order from the CGM court,
before-
correct? Let us say in a case, the judicial magistrate first class is passing an order,
My lord,
or second class judicial magistrate is passing an order for Zimmer.
my lord,
Police is not giving it.
my lord.
So you are coming to the high courts as if the high court is the executing authority.
My lord, petitioner.
We are worse than a,
My lord, petitioner approached before the, my lord, SP by filing a representation, but that has not been. My
file a
lord,
contempt, who is stopping you?
in a similar petition.
But I'm not doing it. I'll be dismissing it. We are not executing court. Who gave us the power to execute?
Earlier, one petition was allowed, my lord.
Or maybe there are hundreds may be allowed, but I am not going to do it. Is the High Court an executing court? 226 is an executing power of the court. You show me the law where the High Court can execute the orders passed by CGM or judicial magistrate first class. You go to judicial magistrate first class, get an order of Zimmer, then rush to the High Court to enforce the order.
Kindly see the, I have filed the representation also, my lord, that has not been, my lord, and dispose of every 8 million.
It will not, never be disposed of. You see, you get a decree in a civil suit. Then you give a representative to the deputy commissioner. Will it help?
No, man.
Then
Well,
how will this help in criminal case?
Well, earlier similar situation.
No, I'm dismissing it. I'll refer to this and I'll be dismissing it. We'll give you liberty to move the trial court or file in contempt. 226, I'm not reducing it to executing court.
Maybe taken up it on Monday, my lord, I'll satisfy my lord.
Wednesday, not Monday. Based on so and so. I'll just make a point, otherwise I'll forget on the next day. By this writ petition, the grievance expressed by the petitioner is that order for Zimma oblique custody was passed by the learned jurisdictional magistrate. But despite the said order, the fertilizer which was seized by the police was not handed over to the petitioner. So in this regard, a representation submitted to the Superintendent of Police has not been disposed of. First of the land counsel for the petitioner submits that in similar matter. In a similar circumstance, this court in the case of Shameen, SHAMEEN Ahmed and another versus State of Assam and others, WPC 7785 of 2022, by order dated 5/12/2022, had issued a notice of motion.
In the meantime, my lord, release the money.
The issue which arises is as to whether the High Court in exercise of its jurisdiction or Article 226 should convert itself to an executing court for the orders passed by the jurisdictional magistrate, or the petitioner has an alternative remedy to have the order of the jurisdictional court enforced by the same court, or to have it enforced by invoking the jurisdiction of this court under Contempt of Court Act. First of all, on the unsaid query, the London Counsel for the petitioner, Mr. M. Islam and Counsel for the petitioner seeks to address the court on the next day. Accordingly, release the matter in the motion column on 7/6/2023. Mr. M. Shetyaran, Government Advocate, is present. Take back this.
Tendency of this petition may not be a bar matter.
No, I'm not issued a notice on that track. But because if you say that, then we'll close it but give you liberty. Well, you have two options. Either on the next day you convince us. Second option is that we close this writ petition and grant you liberty to move the jurisdictional court or come to this court under contempt jurisdiction. What do you want?
On next day, my lord.
Okay, okay.
Highly obliged, your lord. 56.
Yes.
My lord, last token, my lord, observations were made, my lord. To that, rapid, my lord, I want to submit, my lord. Kindly see my paragraph, my lord, is photo 12, paragraph 12, my lord.
Paragraph 12. Yes.
And may I read, my lord?
Yes.
My lord. The petition is going to be restricted that for the expecting consideration for allowing you to deposit the permanent security as well as the additional permanent security for the work in question. This one to in compliance of the order. That is 27/3/2021 in WPC number. Height is speaking order. My lord, I had already mentioned by our that is speaking order. The fact is that, my lord, I did not annex that document, my lord, that was annexed in another repetition, my lord, which is still pending, my lord, 2146, my lord. So rejected the request made by the petitioner for allowing him to deposit the amount of performance security, my lord. Now, kindly see paragraph 13, my lord. There between the being agreed to the speaking order dated 10/4/2023 as well as the subsequent NIT dated 28/2/2023 issued by the chief engineer PWD Assam, not allowing the petitioner company to deposit the additional performance security against the work, namely upgradation of road transfer for the work for 5 years under package number S7260. So despite of the direction of the Honorable High Court to consider the offer of the petitioner for deposit the performance security and additional performance security against the said water work as per LOA dated 6/8/2022. The petitioner company had to appeal the Honorable Court by filing a repetition 2146. And accordingly, while the head petition was listed on 24/2023, this Honorable Court, while issuing notice, had observed that any action taken in pursuant to the speaking order dated 10/4/2023 would be subject to the outcome of the repetition. Now, my lord, kindly come to the order, my lord. Order is at page, my lord, page 35, my lord.
35, yes.
Well, this is the repetition which is still pending, my lord. Now I'll kindly see the order, my lord. May I read, my lord?
Yes.
Well, had Mr. So landed counsel for the petitioner who has put to challenge the order and order dated 10/4/2000, that is the swing order, my lord. Filed by the chief engineer public works department, the said order has been passed on a recommendation by the petitioner and in accordance with the direction to the of this court on an earlier round of litigation by the petitioner. The report revealed that the present case is
Yes.
my lord, additional performance security requirement of which was the subject matter of the challenge in the earlier petition, which was rejected by the court. Therefore, it appears that time was granted petitioner to make the deposit, which was however not done in time on the ground that there was sufficient amount of the petitioner in the form of security deposit, which was entitled from the department and same could be adjusted. The order which now has been passed on 10/4/2023 has rejected the prayer of the petitioner to allow him to submit the performance security and additional performance security on certain grounds, which has been enumerated in the speaking order. We shall notice written with 4 weeks. It is one standing council accepts notice on behalf of the resolution number 1 and 3 so and so. Under paragraph 6, under these facts and circumstances, the court is not inclined to pass any stay order of the impugn order. However, it is observed that any action taken pursuant to the impugn order would be subject to the outcome of the requisition. My lord, against this order, my lord, particular order, my lord, since there is already a subsequent NIT, my lord, there was 3 NIT issued against the particular package, my lord. My lord, well, the second NIT was issued, my lord, during the pendency of a stay order, my lord, of this court, my lord.
Yes.
Well, kindly see, my lord, first NIT was issued on 21/5/2022, my lord.
21/5,
2022, my lord.
22. Yes.
Thereafter, another NIT was issued on 28/2/2023.
28,
28/2/2023.
22,
23, my lord.
23. Okay.
Now, my lord, latest, my lord, which has been put to challenge by this present petition, my lord, on dated 16/5/2023, my lord. That is the latest
Yes.
NIT, my lord.
Yes.
Now, my lord, so far the suppression of fact, my lord, that I have conceived something, my lord. I don't know, my lord, already I have annexed, my lord, I have stated in my paragraph also, my lord. So the allegation, my lord, that is, my lord, it's hurting me, my lord. And so far the this withdrawal of the writ appeal, my lord, they pertain to that interim order, my lord, which I have annexed, my lord. That was withdrawn, my lord. I did not honestly did not think that it should be annexed or not, my lord. That was withdrawn, my lord. And subsequently they have already issued an NIT, my lord. So, my lord, that is why that the writ appeal was withdrawn, my lord.
No, well, that's a wrong statement, my lord. I was there, yes.
Yes, he was very much there, my lord. And my lord, as he was representing the my lord, PWD road department, my lord. Now, my lord, for the concealment of the my lord, my lord, tax, my lord. And my lord, present petition, my lord, it is filed, my lord, on the subsequent NIT, my lord. Again, the same package, my lord. Since earlier, my lord, there was 2 NIT was issued, my lord. Second one was issued, my lord, during the pendency of a my lord, stay order, my lord. That order I have also annexed, my lord. Can you see, my lord?
Well, you also will find, my lord, relevant portion at page 26, my lord.
Yes,
Well, here, I am reading from start from the bottom, my lord. Well, balancing the equities, it is dated that till the next date fixed on 13/3/2023, no coercive action of any measure connected with the additional performance security be taken against the petitioner. my lord. Till 18/3.
this is with regard to which,
Well, earlier, 1052, my lord, and there are
no,
four.
no, there are three NIT.
My lord.
This observation is in respect of which NIT? First, second, or third?
This, my lord, during this operation of this stay order, my lord, second NIT was issued. my lord. NIT dated, my lord, 28.
No,
to
no, this
2000.
page 25, 26 order
My lord.
is in respect of which tender? First, second, or third?
It is first tender.
First tender,
Right.
okay.
Because in first tender, my lord, petitioner qualified, my lord, LOA was issued, subsequent, my lord, additional security and additional performance security was, my lord, demanded, my lord. And challenging that, my lord, petitions are filed, my lord.
Okay, so
Now, my lord, can you see till 13/3/2023, my lord, no coercive action was not to be taken, my lord. But they had issued the NIT, my lord, on 28/2/2023, my lord, during the operation of the stay order, my lord. And now, my lord, anyway, my lord,
it is not a bar.
no,
Coercive, issuance of tender is not a coercive step.
not, yes, madam, not a bar. Is
Yeah.
only not to take coercive action. madam.
Yes.
Yes. Now, my lord, see, already, my lord, by the speaking order, my lord, the coercive action has already been taken, my lord. And the speaking order was passed, my lord, against the order, my lord. I am referring, my lord, kindly page, come to page 32, my lord. And operative portion you also will find page 33, my lord.
33.
My lord. Again, which the speaking order was passed, and that speaking order has challenged in the WBC number 2146. This is the order, my lord. May I read the, my lord, ministration?
Now, this pursuant to this order, this is order dated
My order dated 27/3/2020.
27/3/23.
And the speaking order was passed, my lord. That is the subject matter of the repetition
No,
number.
just a moment.
Right.
Yes, sir. Yes. Now, did you submit this performance security?
My lord, you won't, but the department did not accept. my lord. They have issued an speaking order saying that we cannot accept that additional performance security. my lord. That order was, that speaking order was challenged in WBC number 2146. my lord. That is pending it. And while that 2146 is still pending, my lord, they have issued the into NIT, my lord, one.
Where is that speaking order?
Speaking order, my lord, that is not annexed, my lord. That is.
Well, little buns I have furnished them. One buns I have furnished them.
Oh, acha.
There lordship will find it at page 18. There's a typecopy, original is at page 21.
My lord, I'm having this original one.
Just a moment. Okay, now, what is your prayer in this repetition?
Well, is a repetition method. Well, for setting aside cost in the NIT method, in NIT method, which is the latest NIT.
16523, why? On what ground?
Well, on ground that, well, since the package is already a subsidized method.
We'll have to dismiss your repetition.
Protection has been given at page 37, madam.
Huh?
In the, madam, one more repetition is pending, madam. Their protection has been given, madam. Where, madam, he has challenged the speaking order. The Honorable Court, page 37, has held that para 6. Under this facts and circumstances, this court is not inclined to pass any order of stay of the impugn order. That is a speaking order. However, it is observed that any action taken pursuant to the impugn order would be subject to outcome of this repetition. Now, my lord, if this, my lord, NIT has been issued, it will be subject to outcome of the repetition, my lord. There is no bar. Now, challenging this, my lord, order when no interim protection was given as per the terms of the petitioner, he approached the Honorable Court challenging the same. Now, when the Honorable Court division bench, my lord, observed that, my lord, is going to dismiss the, my lord, writ appeal, he withdrew it. It's not that because of the, my lord, floating of the new tender. There's a wrong statement made, my lord. I was there, my lord, when the appeal was heard. And, my lord, if at all, my lord, this order will cover, my lord. It will be subject to outcome, my lord. Let this, both these matters be taken together. And lordship will see, my lord, what is the, on what grounds, my lord, you can challenge it now, my lord. Because, my lord, this is the 8th round of litigation, my lord. 7th round of litigation.
No, that is okay. But your submission is something which is intriguing me. I'm saying I'm dismissing the repetition. You say that you
Lordship,
hear
yes.
it together.
In that case, my lord, I fully agree with you.
No, it is
Otherwise,
not is your own prayer to examine it.
no, no. Lordship
I
will
was
see-
saying that I'm dismissing it, then you
Why
said,
not?
no, you say his. So we'll not disappoint you.
So in that case, my lord, I have nothing to submit.
No, but
Repeatedly,
disappointing.
my lord, they have been, my lord, approaching this honorable court with the same ground.
No, but the face is always smiling. It's very hard to disappoint.
Otherwise, my lord,
Yes, but Mr. Hawk will be dismissing your repetition.
We are pray for listing this matter along with the.
No, that will not permit.
My-
The simple thing is that that your what do you call this, on the day you are moving it, the performance security is also has been what you call completely forfeited. The second is that I find in some one order where it is written that you are unable to do that work. Some order of the High Court.
That is in respect of some other packages, my lord.
It's okay,
Total-
but you have
they
expressed
are-
your inability to do so.
My lord, there
Where
are,
is that? Where is that observation? It's one of the orders, the High Court order.
my lord,
You have expressed your inability to work in 3 packages.
my lord, that is page 33. my lord.
Page 33. So because a person who has expressed inability to make such offer in respect of 3 works,
My lord, may I
so
submit, my lord?
why should we accept your
My lord,
statement here and then stay the
My lord,
tender?
May I submit one thing, my lord, just one thing. Here, my lord, additionally, my lord, bid security, it was ready to offer bid security or deposited, my lord. Subsequently, my lord, the additional performance security as well as performance security was demanded. That was the huge amount, my lord. That's for the huge amount, my lord. Again, the present package, my lord, it will come to total amount 2,58,27,000. But similar, there are some other 3 packages, my lord. Similar demand, my lord. Ultimately, my lord, some have to look in his pocket also, my lord. So that is why, my lord, other 3 packages, here honestly, my lord, he has honestly admitted, in respect to other 3 packages, I am honestly giving up, but at least one package, my lord. At least my prayer is that at least this package should be considered, my lord. He had honestly Well, it's standard 3 other packages, only this package matter. And this is.
There's no honesty in in a business, you see.
My lord,
You took a tender,
my lord,
correct?
my
That
lord,
means by taking the tender, you prevented somebody else to do the work.
my lord, yes,
And
obviously.
then you don't give that security. Additional security. Then you say that please adjust the earlier security with the
My lord,
present
pending
work.
bill, pending bill.
Yes, against the pending bill. So you see, you are in fact imposing your own conditions.
My lord. Considering,
After giving you a tender work,
my lord,
whether the department will go by your dictates.
my lord, yes, my lord, kindly, I'm again coming to that diagram and particularly, my lord. Already lots of done for my lord. Just for one.
Page
Yes, 33, my lord. I'm reading it there. Particular, my lord,
33,
you have
yes,
lots of already
yes.
done, my lord. The petitioner had raised a grievance on the issue of requirement of additional performance security on the work on certain grounds, which however has not been accepted by this court. Thereafter, though there have been other developments in the case, the petitioner had expressed his willingness to make the said deposit, which has been rejected only on the ground that the work in question has been retendered. Though the rejection of the authorities per se.
No,
does not-
Mr. Islam, Mr. Hawk, you're not be able to follow me. You see, I am not on the merit of these matters. You see, number one, for whatever reason, for any reason whatsoever, one of your tenders
Right.
was cancelled and the security deposit forfeited.
Right.
Therefore, you will never be in the good books of the authorities.
It all costs also, my lord. reputation
Correct.
also, my lord.
So we can't force them. For you, we can't stop the tender process. Once you don't, once you surrender your work, for whatever reasons, and you have expressed before the court that you have surrendered the works, then we can't permit the what you call the authorities to give you work, and under any circumstances, you become a defaulter.
My lord, only respect of the other 3, my lord. You had surrendered
No,
only
no.
other 3, my lord. This package, my lord,
Be it one or be it three or be it half,
my lord.
even if you surrender half of the work after performing incomplete work, you surrender.
Right.
It disentitles you to a different to consideration for a different contract.
My lord, that aspect, my lord, was considered, my lord. Though the rejection by the, just I'm reading, my lord, though the rejection by the authorities per se does not appear to be wholly unreasonable, as the work has already been put to retender. Considering the peculiar fact and circumstances, this court, in exercise of its equitable jurisdiction, as an exceptional case, directs the authorities in question, namely the Chief Engineer Public Works Department, Border Roads, to reconsider the offer made by the petitioner.
He
regarding-
considered it and rejected it.
Yes.
That is a challenge.
Yes.
So therefore, till that challenge of the High Court is what you call finally heard and disposed of, there will be hundreds of tenders coming in
Right.
for all these 2 years. When the High Court is not disposing it off, you are expecting the High Court to stay all the tenders of the authorities?
No, not that.
No, you can, you see, definitely for next 2 years, you can participate in 100 tenders. Let us assume that the PWD is issuing 100 tenders in next 2 years. You can participate in any of the tenders. So because if we entertain in your writ petition now, that means for next 2 years, all the 100 tenders of the PWD would be stayed. Why one case? We'll have to accept your submission for all the 100 cases which are going to come.
My lord,
Then am I setting a right precedent?
yes, no.
Then it is on that ground we are dismissing it. But this is a proposition we can't accept.
Right.
That is why when Mr. Gogoi said that it can be heard, I expressed my displeasure smilingly. Correct? No, this has to be dismissed, Mr. Hawk. Mr. S. Hawk, Learned Counsel for the petitioner. And Mr. B. Gogoi, and Standing Counsel for the PWD. Appearing for respondent numbers 1 to 4. Who's for 5?
4 is union, brother.
Achha, 1 to 3.
4 and 5 is okay.
4 and 5, Mr. Ekinath, then
Okay, doctor.
Standing Counsel, sorry. You are appearing as CGC. As CGC for respondent number 4 and 5. By Filing this writ petition under Article 226 of the Constitution of India, comma, the petitioner has prayed for question of the interim NIT dated 16/5/2023 in respect of the work of inverted commas upgradation of roads from T05 dash Dimaruguri, DIMARUGURI, Kamarpur, KAMARPUR road, including cross drainage works and routine maintenance of the works for 5 years under package number
Yes,
AS-17-260, comma, PMGSY dash Roman 3 capital, comma, batch 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 numerical 1, comma, 2022-23, issued by the chief engineer PWD within bracket border roads, bracket goes Assam, within bracket respondent number 2. Next para. In brief, comma, the case projected by the petitioner is that he had previously participated in NIT dated 21/5/2022 and the petitioner was selected and for the work and was issued a letter of acceptance at the contract price of rupees 18,39,13,378, and the petitioner was asked to give a performance security for an amount of rupees 45,98,000 and additional performance security or rupees 2,12,29,000 for quoting 17.86% below the estimated construction cost. Full stop. Agreed by the demand in respect of additional performance security, comma, the PW's chief engineer is respondent number 2.
Yes, sir.
The respondent number 2, comma, the petitioner had approached this court by filing WPC 5301 of 2022. Full stop. This court by order dated 7/2/2023, comma, dismissed the said writ petition on the ground that the legality of the tender clause was not challenged. Full stop. The respondent number 2 again issued a notice of demand for submitting additional performance security. Performance security as well as additional performance security. Full stop. This time the petitioner submitted a representation dated 22/2/2023 to the chief engineer, to the respondent number 2, to adjust the additional performance security in the manner prescribed. You are writing here prescribed by the petitioner. Your language in paragraph 8.
Right.
Is that the performance security terms is prescribed by you. Without hampering the interest of the in the manner prescribed. Full stop. So the petitioner is referred to undertaking which is not relevant and therefore not narrated herein. It would suffice to say, to mention that the petitioner approached this court again by filing WPC 1057 of 2023 for a direction to the respondent number 2 to consider the representation dated 22/2/2023 and not to take any coercive steps. Full stop. This court issued a notice of motion by order dated 24/2/2023. And the respondents were directed not to take coercive measure against the petitioner in respect of the additional performance security till 13/3/2023. Full stop. Next para. On 28/2/2023, a fresh notice inviting a fresh NIT was issued by the respondent number 2. By cancelling the letter of acceptance dated 6/8/2022 issued to the petitioner. Full stop. The petitioner now claimed that he was ready and willing to deposit the additional performance security in terms of letter dated 16/2/2023. And as the date had expired, the petitioner approached this court again by filing WPC 1725 of 2023 for a direction to allow the petitioner to deposit the additional performance security. Full stop. This court by order dated 27/3/2023 asked the respondent number 2 to reconsider the offer of the petitioner. Within a period of 10 days. Full stop. The respondent number 2, by a speaking order dated 10/4/2023, rejected the prayer of the petitioner and accordingly agreed by the rejection of his prayer. The petitioner has approached the court again by filing WBC 2146 of 2023 to seal the speaking order. Full stop. This court by order dated 24/2023, 2020 in WPC 2146 of 2023 observed that any action taken pursuant to the speaking order dated 10/4/2023 would be subject to outcome of the writ petition. Full stop. In the meantime, the respondent number 2 invited a fresh e-tender dated 16/5/2023 for the same work. And the aggrieved petitioner has approached the court again for filing the present writ petition. Full stop. Next paragraph. The Lawrence Standing Counsel for the PWD has submitted that the petitioner has withheld vital information regarding dismissal of writ appeal number
135 of 20.
135 of 2023 by order dated
28/4, page
28
28/4/2023.
28/4/2023 on withdrawal. Full stop. Accordingly, it is submitted that the petitioner is disentitled to any relief. Next paragraph.
Permitted means already been protected by the earlier order passed in the execution number
So it is also submitted that
2146
by virtue of
24/2020.
the order dated 20 April 2023, this court had already protected the interest of the petitioner, for which he would be disentitled to any relief in this writ petition. Next paragraph. The court has observed from the contents of the order dated 27/3/2023 passed in WPC 1725 of 2023 that the petitioner had been offered 3 works.
Earlier 4 works.
Achha, 3 works in addition to the
Yes.
work in question. And the petitioner had made a statement and the learned counsel for the petitioner had made a statement that the petitioner was not in a position to offer additional performance security in respect of 3 other works. Full stop. Accordingly, it is submitted by the learned counsel for the petitioner that he is offering the additional performance security in respect of package number ES-17-260. Full stop. Under such circumstances, when it is a matter of record that the petitioner had not been able to offer additional performance security in respect of 3 other works, the natural corollary would be that fallout would be that the letter of acceptance issued in respect of 3 other works must have been recalled. First of all, although the court has no material to that effect. First of, therefore, and the next paragraph, therefore, when the petition is already a defaulter in respect of 3 other works, and that despite 4 rounds of writ petitions, comma, the additional performance security in respect of package number AS-17-260 was not provided within time. Comma. Just make that full stop, adjust the language, and was not provided within time, full stop. Therefore, comma. If the proposition of the petitioner is accepted, that till the issue of till the dispute regarding the speaking order passed on
10/4/2020.
8
Taking order. 10/4/2020.
10/4
Yes.
2023 is not adjudicated by this court, comma, the subsequent tenders we stayed would lead to another situation where the PWD may, where the respondent authorities may issue further tenders. But they would not be able to proceed with any tender till the issue raised in WPC 2146 of 2023 is finally decided. Next, moreover, comma, the court finds that the security offered by the performance security offered by the petitioner has already been appropriated, right?
Yes.
And submitted in connection with package number AS-17-260 has already been appropriated. Comma. Merely on the issue of additional performance security, comma, no point would be served to stay the present tender process, because the issue of because the because this performance security has already been appropriated,
Yes. It is reflected in the order, in the speaking order.
which is reflected in the speaking order. Full stop. Next, therefore, comma, the court finds that as the interest of the petitioner has already been secured by virtue of order dated 20 April 2023, passed in WPC 2146 of 2023, no case has been made out for interference with the present tender process. Bearing NIT number capital C public PMGSY public 01 public 2022-23 public 62 dated 16/5/2023, issued by the chief engineer, comma, PWD within bracket border roads, Assam. It is further added that the court is conscious of the fact that by passage of time, there is a likelihood of cost escalation. And as the work in question relates to the construction and maintenance of roads under PMGSY scheme, it would not be in public interest to stay the tender process. Next para, however, it is provided that in the event the petitioner is agreed by the tender process, it would always be open to the petitioner I approach the civil court for claiming compensation and or damages in accordance with law. Full stop. In view of the discussions above, the court does not find any merit in this present challenge to the tender process and accordingly the petition stands dismissed at the motion stage without issuance of without issuance of notice on the respondents. Yes,
That forfeiture part, my lord, it is a bid security was forfeited.
that's a bid security, not
Page 19
performance
of the
security.
speaking order in the compilation. Page
It is bid security, not
It is
performance
bid
security.
And
As a bid security, not
Yeah.
performance security.
my lord, that bid security was forfeited during the pendency of the interim order.
No, whatever be, but it
My
has
lord,
been,
anyway,
it
but
has been
I'm
done.
pointing out.
It has been done.
My lord, high level.
Obliged, ma'am.
Continue it.
Obliged.
Yes, I have got my question. In fact, for the housing board, Mr. T. Gogoi, standing counsel, he appears, but he's out of station. But still then I have got my instruction. Here the actual, it has allotment was to Utpal, Mr. Utpal Kumar Saikia. So
Yes,
he has again sublet to the present petitioner. He has been in possession. And finally, notice has gone in. After the notice, he has admitted that he's in possession. He wants to vacate it, but he wants some extra time. So all these instructions, there are in total four instructions. The first two related to the original LOT, and the subsequent twos are with regard to the present petitioner who is illegally in occupation of that as a subtenant.
but he may be there legally or illegally, but has any action been taken? No.
And as at present, already that notice has gone in. After that, present status, I don't know.
So he's surrendered it.
Yes. Last but one letter, that is with regard to that present petitioner, that 24/5/2023 is the letter addressed to the petitioner, and subsequently he has replied on 26/5.
No, you see,
Yes,
if somebody has surrendered the flat, the original allotee is Utpal Kumar Saikia,
yes, he's,
correct?
yes.
Then you have to advertise and give it to whoever.
Exactly, that is the case. Exactly. But now he is claiming that he needs to be allotted with.
No, that
who is in
you
possession.
can't be singled out, Mr.
Original allotee has admitted in clear terms that he is known. to-
Mr. Fukan.
Lordship,
You can't have a vested right.
Lordship, that is right, Lordship. But my lord, my advance is there also within 7 days, Lordship. It will be difficult on my part to vacate the land, vacate the flat, Lordship. And my lord, in that case, I am referring to section 54 and 55 of the Assam State Housing Board Act 1972, wherein it is reflected that reasonable opportunity may be given to the any unauthorized occupant, Lordship.
No, in fact, my
Show me the
understanding.
right, I don't have it regularly.
Here he was trying to portray the picture that he is unauthorized occupation, but actually he is not in picture at all. Because he has been in subsequent subletted by the original holder. And he also admits that he is going to vacate it, but he needs some extra time beyond 7 days.
And 55. Also subsection 2, Lordship, yeah.
Demanding for- demanding for- yeah. 24.
31, 1, 2.
Okay, then you have to comply with 54B and 2.
In fact, his intention was something different because from his petition I can make out. He was in February, he was praying that since the original allotee was not residing, so he wants a allotment of that flat. Finally, he has been served with the notice. Now he's claiming the benefit of 54, which in my humble opinion doesn't attract him. Because he is not an unauthorized, he is illegal in fact.
Illegal and authorized is same, interchangeable.
Maybe the synonym is.
It would be interchangeable. It can't be, because if you don't say illegal,
But that time period, if at all, that reasonable opportunity of 7
when
days,
you have an act, you have to follow it.
yes. But that reasonable opportunity of 7 days, so he's praying that he needs some extra time, so that lordship may fix as to.
No, we'll
what
say that
reasonable-
you will reconsider and pass orders in accordance with 54 1B.
Yes.
The procedure prescribed in 54, we'll say that. We dispose of the writ petition, then we're
Yes.
not keeping it pending.
Yes.
Mr. R. Fukan, and counsel for the petitioner. And Mr. S. Barbar and the government advocate appearing for responding number.
Sorry, I appear for 1, but at the moment I have got the instruction on behalf of 2 and 3.
Okay, respondent
Lordship may
1.
note the name.
Okay. We say respondents then,
Yes,
the respondents. You want me to record the name of Mr. Barbar?
yes.
You want me to record the name of the standing council and then say that you are appearing on his
Up to
behalf?
your lordship, because that may be.
Okay, then we record your name.
Yes, this name.
Your name?
NK Das.
He's for
NK
one,
Das.
huh?
On
Mr.
the-
N.K. Das. Learned counsel appearing on behalf of Mr.
TR Gogol, respondent number 2 and 3.
Okay, T.R. Gogoi,
TR.
TR Gogol.
G.R. Gogoi,
T.
T, okay, T.R. Gogoi. Standing counsel for respondent number 2 and 3. Next para. The petitioner is in unauthorized occupation of LIG flat number 4/4 under what is RHS?
Not sure with this abbreviation because I think that's the society name or.
Okay, a Tilachal Housing Society. No, just like LIG flat number 4/4 under RHS at Nilachal Housing Complex, Bhetapara, Guwahati. So it is projected that the petitioner came into possession through the original allottee, namely Utpal Kumar Saikia. He has been served with a notice dated 24/5/2023 for vacating the said flat within 7 days. First of all, it is submitted that under the provisions of section 54 within bracket 1 within bracket small b, the petitioner was entitled to a 30-day notice, no, 1 month's notice, and that he has a right to defend himself under subsection 2 of section 54 of the Assam State Housing Board Act of 1972. In the first to write this, section 54AB of so and so. The next part you can write so and so thereof. Full stop. In view of the submissions and according to this petition is filed for setting aside and quashing of the notice dated 24/5/2023. Next paragraph. In view of the nature of submissions made by the Land Council for the petitioner, the court is of the considered opinion that instead of keeping the matter pending, it would be appropriate to delegate the petitioner to approach the Commissioner, Assam Housing Society, Assam State Housing Board within bracket respondent number 2. Sorry, 3.
Number 3 lots.
And make a prayer for extension of time to vacate as per the provisions of section 54(1)(a) of the Assam State Housing Board Act of 1972. And on receipt of such representation, the Commissioner, Assam State Housing Board within bracket respondent number 3 shall take note of the mandate of the period of time as mandated in section 54(1)(b) and pass appropriate orders thereon and to dispose of the eviction, the issue relating arising out of the eviction notice by compliance of the provisions of section 54 of the said 1972 Act or any other relevant provisions. First, next, the petitioner shall produce a certified copy of the order before the office of the respondent number 3, along with this representation for extension of time. First, with the aforesaid observation from matters since closed at the motion stage without issuance of notice on the respondents.
So within what time limit he is to approach the authority? Because in doing so, again, that
Within 3 days, because today is Friday, Saturday, Monday, within 3, make a date within within 5, 6. Shall approve within-
No, Lordship, in
No,
that
no,
process
7
again, you-
days, 7 days will go, he will evict you. So you'll have to go by 5 and he'll extend time on consideration of that. Within 5 he'll appear.
Till then, my interest may be protected.
And,
that is
and-
presumed.
until appropriate decision is taken on the representation will be filed by 5/6/2022. The petition shall not be evicted by the respondent number 3.
Obliged.
You take your book.
59.
You have to issue notice here.
Lordship, my problem is that it's a current account. If Lordship is pleased to come to page.
It's okay,
24,
but if I give you an interim, nothing remains in the rate petition.
no, if necessary, we can give bank guarantee also for that amount, 26 lakhs. My whole business transaction is stopped. For no fault of mine, we do not know what is the case. The transaction took place in the month of November.
Okay,
Everything is on white.
it's okay, but
He may have done some mischief, the purchaser in Impal or in Hyderabad. We do not know what cybercrime he has done. If required, we can give full amounts, Lordship, the bank,
make your observation, let the authority take a decision.
bank,
Huh.
the bank.
No. The, what you call, the.
They wrote to the HDFC Bank at Guwahati, Lordship.
No, you see, the seizure is made by the police authorities. HDFC Bank will not take a decision. We can only ask the cybercrime authorities to make an alternative arrangement so that you can operate the account. You are interested in starting the operation in the
They are
account.
not responding. We are writing letters to
No,
them.
no, we are issuing the court order. It will be on the basis of court
If
order because
Lordship,
I
because
can't
the
give
only
you-
thing is that the transaction was of 26 lakhs and that was the only amount. The rest of the amount is to other bank loan. And
This, where is the, what you call, communication from the cyber crime?
they have not communicated anything to us. They communicated to the bank concerned, the current account bank, Lordship, where I am maintaining the account. That bank has all of a sudden, without any rhyme or reason, has stopped and closed the account.
It's okay, but what is the extent of money which has been communicated? There must be
Yes, that is
something,
26, page 24. Bank transfer from customer account against down payment of Audi Q5, 26 lakhs 20,683. The other amount they have obtained from the HDFC,
transaction is FIR filed.
page 24. Lordship.
No, but this is under nobody's signature, this, the handwritten transaction.
This is a bank statement, Lordship.
No, handwritten the transaction against which FIR filed.
There is, we do not have any affair or nothing, Lordship.
No, in my copy, this page 24, there is a
Page
note made.
24. Yes.
This is not,
No, this is our handwriting. We have just said the transaction against which FIR file.
no, sir, how?
So this amount, Lordship will kindly see the money against the down payment lot on top, name of the person's Sachikanta Sharma. He was the purchaser. He gave this down payment. And subsequently, the rest of the bank loan amount, Lordship, it has come from another HDFC Bank of Impal. So where we do not have any account. Our account is here only. And if Lordship is pleased to look at all the other transactions, we receive various amounts from various other purchasers.
No, you see, Mr. Saike, there's no difficulty in following you, but the problem is that an amount has been seized by the cybercrime police, right? The nature of crime for which it has been
Not
analyzed.
amount, Lordship, not amount. It is not about the amount. These gentlemen must have committed some cybercrime.
No, I'm not on that. I'm not on the person. My question is different. You see, supposing from account of X, some cybercrime was done and the money was transferred to the account of A. Correct?
Yes,
Now A's account has been seized.
seized.
Now this
We
money,
received that money.
no, money entered into the account of A.
A.
Is
I
is
am
the,
A.
no, is the entire, I'm not,
Then I'm given, suppose I am the A.
supposing you are A,
I am
then,
Green Valley Travels.
then you see what funds is a proceeds of crime, we don't know.
Absolutely
You,
correct,
you,
Lordship.
you,
Now,
you may
if-
have 100% right transaction, only one incorrect transaction, correct? And that is also your,
No,
you say
my
that,
transaction is correct
no,
also.
no, that you see it's a pursuit of crime ultimately.
It's a proceed of crime, number one,
So
Lordship.
in
The
a
only
pursuit of
thing is
crime,
that
wherever it is gone,
while
going,
my current account is seized, I have received a portion of that money. Against what? I am submitting the documents before this honorable court.
that's
It
what
is
I'm
a-
asking.
it
You
is
see,
a
this,
Legal sale of a vehicle.
no, you see, that it is only this transaction which is a pursuit of crime. Where is that information?
In our mail, we
You
have.
see, in the
said-
pocket of, A,
Yes,
there is
Lord.
100 rupees,
Yes,
out of which 1 rupee is a pursuit of crime.
and understand, Lordship.
So what is, how do we identify that particular transaction? That is the question.
Lordship will kindly come to page. This is 33. So the managing director of Green Valley, Richard Sharma, she wrote to the cyber. This is regarding FIR 375 of 2023. The transaction of 26 lakh so and so on 5/11/2022 against which FIR was made has been done in the HDFC bank account so and so. Here to inform you that the account belongs to Green Valley Private Limited, Audi Guwahati, authorized dealer of Audi in Northeast India. The transaction of so and so was made by Sri Sasikanta Sharma towards the purchase of Audi Q5. Here I am to inform you that Sri Sasikanta Sharma was the first time buyer and he is a resident of Imphal, Manipur. He wanted to purchase an Audi Q5 for which he gave the booking amount of 4 lakhs through a card swipe on September 2022. And the down payment of 26 lakhs odd rupees was made in November 2022. All the rest amount of 36 lakhs 95,517 for the payment towards the Audi was paid through the bank finance, which was done by HDFC Bank. I have attached all the details of the transactions made by Sasikanta Sharma in our account. I have also attached the details of the card swipe transaction, the bank transfer, the bank finance sanction letter, his PAN card, Audi Q invoice, and all the documents related to the purchase of the vehicle, which includes the registration. The transaction of 26 was done through the customer's own account to our account in respect of payment against the car he purchased. Hope all this evidence is sufficient. I am to inform you that HDFC bank account of ours, which is now locked due to the above transaction, is the only current account that we operate,
Just a moment,
and all
just a
our
just a moment. Prevention of Money Laundering Act.
Money laundering crimes. Section.
You see this 5, Money Laundering Act.
Money laundering.
Yeah, that.
Yes,
So this
okay.
is section 5. Because the court will not be able to, I'm just speaking my mind, you see. I primarily feel that before passing an order of releasing of the attachment, because the attachment is done by an authority which is prescribed, it is a director or not below the rank of deputy director. Within a period of time, after this attachment is made, all the orders passed or all the steps taken has to be sent to the adjudicating authority. I'll just, if you see section 5, subsection 5, then you will come to the director or any other officer who provisionally attaches any property under section 1 shall within a period of 30 days from such attachment file a complaint stating the facts of such attachment before the adjudicating authority. So you see, under the scheme of the act, and if you find the PMLA order of the Supreme Court, I forgot the citations, 22 last part.
But
Then
my
you see
humble
the
submission is that
226 will have
very
limited
limited
powers.
scope. But this is not a case of PMLA.
Yes, I found it somewhere. In this page, somewhere it is there, PMLA.
In spite of our repeated request, not
No,
a single FIR has
I
been
found
forwarded
somewhere.
to us.
I won't remember it because I found a mention of somewhere, PMLA.
Para sheet we have, I think, Lordship.
No, I don't know, I won't remember because I just cursorily peruse not for any other
Yes, yes.
purpose.
Para see page 6.
Huh.
It's called due to ongoing investigation under the PMLA
Yes,
against one Sri so and so, to whom the
Yes.
petitioner company has made a bona
because
fide.
then without notice to them, I can't pass an interim order.
That is the problem now.
So
This
we
is
can send it by email, we'll give a shorter date. You can send it by
our
email.
only concern is that this is the only current account of us.
No,
Number
I understand. See the-
Suppose in my account, if somebody deposits some money and he is involved with some PMLA case, why should I suffer?
no,
Because
that is
this
okay,
is why
but
this is a
it is-
226
But this
proceeding.
inquiry can't be done by the High Court. I
I
have the,
understand, but here I am producing all the documents. It is not that we sell the car only to Sasikant Sharma.
no, I understand, no
I
difficulty in
understand.
following you, but you see,
In
we have
certain
limitations of
situations,
power.
So in certain situations, Lordship, we have to look it from a different perspective.
No, but the High Court doesn't have power because you see, then you, Mrs. Vagia, you see, the difficulty is that it will be usurping of the authority. Technically, I'm saying,
Right.
I'm not on the
Right.
principles of law, but
So
what
what
happens is,
maximum Lordship can be the proceeds of the crime. Now proceeds of the crime, we very clearly said it is 26
no,
lakh,
it is attachment.
Lordship.
It is attachment, and the Supreme Court has very clearly said that once it is an attachment proceeding,
Then
which has been,
my next line of submission will be that Lordship may attach the complete amount which is deposited there as on date. Suppose there is 60 lakhs in my account. That 60 lakhs, they can freeze it. Let me operate the account. Because my salary, my fee, all the other customers' transactions, everything routes through that particular current account. Whole amount, what is at the time of seizing or at the time of freezing, I will not touch a single penny from that.
but I can't do it without notice. That is the problem is, that's why I'm telling you time and again. You see, what
Now,
happens is
now
that,
the problem is this investigation is done from
no,
Hyderabad.
no, I'll tell
Had
you.
it been
I'll tell
Guwahati,
you,
Lordship, or in
it's
Assam,
a legal issue, which will come up. The legal issue is that once
then
there is a-
Lordship will kindly
then once,
issue notice.
no, you
We
see,
said
I'll
that.
tell you, once there is a adjudicating authority, then under 226, we will not have the power. And therefore, the court, instead of the court saying that we don't have what you call jurisdiction, instead of that, I am issuing a notice for a short date. And make it clear in the order that if the authorities can allow the bank operation to be made, so you'll only suffer for 4 or 5 days. But if I decline the authority, then what happens is that you will be forced to go to Hyderabad and then appear before the adjudicating authority. That is the difficulty. PMLA decisions I have seen
Lordship.
in adjudicated authority when it is there. The High Court will be it has been even in the last challenge PMLA 2 days back, the challenge was made to the order and the Supreme Court came very heavily on the issue of challenge.
Lordship.
So I was trying to see that, but I couldn't see the order. But the problem is that the High Court under 226, without issuing a notice on the in a PMLA matter, it can't do it.
I agree to your lordship. Let the notice be
I'll
issued.
give you,
And
I'll give you a
lordship
short
may
date.
also-
I'll give you 7 days notice.
7 days notice, and lordship may also allow us to send a email copy of the notice
Yes,
to
we are
this
doing it.
authority,
We are
and
doing
they
it.
will respond.
We are doing it.
Yes.
We will voice what is your concern. We'll voice that.
Yes.
Well, without notice,
Yeah,
I can't do it.
that will suffice, Lord.
We can't do it. Because validity of the act has been upheld twice.
Yes, Lord.
And yesterday
Very
was,
stringent act, Lordship. Yes,
yesterday or day before yesterday was the 3rd day. When the Supreme Court upheld everything. So it includes the power of the adjudicating authority. That is my difficulty. Third, Mr. D. Saikal and senior counsel, assisted by Mr. D. Gogoi, learned counsel for the petitioner. The petitioner company is a dealer. Is a automobile dealer, public distributor. Which is operating a current account through which all the transactions of the company are routed. Full stop. On or about. What is the date?
It is on 25th.
25
5.
5/2023. The petitioner came to know that the authorities of HDFC Bank, Beltola branch, had frozen the operations in the current account number 502-000-1513-4094. The learned senior counsel for the petitioner has submitted that the petitioner had approached the bank but did not get any information regarding the transaction for which the Cybercrime Police Station, Hyderabad, had frozen the operation of the account. First off, it is submitted that from the information gathered by the petitioner, one L. Shashikanta, SHACI, no, sorry, SHACHI, KANTA, Sharma, SHARMA, had purchased a automobile from the petitioner in the month of November 2022. And the transactions with the said customer was a bona fide transaction. And the petitioners are informed that some part of the purchase money deposited by the said person, that LCC saying right within bracket respondent 5. The said respondent 5 was purportedly a proceeds of crime, which is being investigated under the Prevention of Money Laundering Act, 2002. Nonetheless, the learned senior counsel for the petitioner has submitted that the involvement of the offense is merely a information gathered by the petitioner without having any official knowledge.
Official knowledge, and bank is also not
And,
giving
and
us
the
any
bank,
information.
and that the bank and the HDFC Bank has also not disclosed anything to the petitioner. Full stop. It is submitted that the petitioner has provided all the documents and has annexed all the documents relating to his genuine business being conducted. And it is submitted that no part of the no part of the transaction of the petitioner is under any inquiry by the by any police or investigation agencies. Next, but accordingly, the Ghana Senior Counsel for the petitioner has submitted that the petitioner is ready to provide adequate security in respect of the arrest money, which is which was proceeds of crime insofar as respondent number 5 is concerned. And that the petitioner is interested to have the current account being operated because that is the sole account for all transactions, including payment of salary and transfer
Other
of money to
regular
the
transactions.
principal for obtaining vehicles. Yeah, and all of the business transactions. Next paragraph. As the petitioner is a resident, is doing business within the jurisdiction of this court, and the account being operated also falls within the jurisdiction of this court. Or the court is inclined to issue a notice returnable on this second, 9/6/2023. Notice including notice on the prayer for interim relief. Full stop. Under the circumstances, the court permits the petitioner to collect the copy of notice, collect a copy of notice from the registry so as to send it by email to the respondents and to file a affidavit of service on the next date fixed. Next, the respondent number 1 and 2 are also put to notice as to whether they have any objection as to attach only that part of the amount which is allegedly a proceeds of crime and permit the petitioner to operate his current account. Next paragraph, list on 9/6/2023.
We have a little further prayer, Lordship. Whether this respondent number 2 may be directed to give us the informations which they have received from the
Just one
Telangana.
more. Also, you should notice the petitioner shall also take step by within 2 days for service of notice under respondent numbers 4 and 5 by registered postal delivery. The Learned Counsel of the petitioner is permitted to correct the postal receipt number and submit postal tax report prior to the next date of listing. Just add one more that the respondent number 2 is also directed to provide the petitioner with with information relating to the attachment of the account of the petitioner.
By tomorrow, because tomorrow is a working day, Lordship,
Okay.
so that I can promptly
Yes.
take all the
Okay.
information.
On furnishing a certificate copy of this order.
Lordship. Highly obliged.
21.
Yes. Mr. Gogoi, we'll have to issue notice in this matter.
We should notice because that
He-
particular issue is pending honorable apex court also. Last week, we have.
No,
filed
but you see, I have a different, it may be pending. I'm not saying it's anything to do,
Also,
but I have my own reasons.
also.
And I'll tell you why. Number one, the even under the Hindu law,
Lordship,
right to procreation is always there,
lordship,
correct? It's a duty of a man to
lordship.
procreate. Second is that irrespective of the age, a right to procreation will be there. It's a fundamental right.
It's there, but lordship, there's a statute is there, lordship.
It's okay,
As per,
but-
we have to do as per the even
It's
lordship.
okay, but
In this point, lordship, there is a national board is also constituted lordship. They have opined that lordship, the age which was fixed by the age was which is determined in the act and rules. That will be proper lordship. Just justification they have given lordship.
no, that may be there, but I have to issue notice.
Lordship may issue notice, we will reply it, lordship, because that particular issue is lordship. The honorable apex court is dealt with because various state there is a repetition is filed lordship.
Mhm.
So one repetition is before the apex court, then apex court lordship directed us to lordship, file the affidavit lordship. And we have filed affidavit on 16/5 lordship.
16/5.
16/5
Okay.
and lastly that matter was listed lordship. That was listed on lordships. On 16/5/23 lordship.
16/5/20.
It was listed. The WPC civil is lordship 5222023 lordship.
WPC civil
Lordship
5
5222023 lordship.
522
2023 lordship.
2023.
23 lordship.
Okay,
Sumita Rakshit and Ananda versus Union of India lordship.
just write that name. Sumita
Lordship Sumita Rakshit.
SUM
SUMITA RAKSSIT lordship.
versus Union of India.
Lordship. And another one also there lordship is Arun Mothuvel lordship. ARUNMUTHUVEL. It's WPC lordship 7562022 lordship. In both the cases, union has filed affidavit lordship,
Okay.
and I will bring it record lordship.
Oh, okay.
Lordship.
Her Mrs. R. Chaudhary and counsel to the petitioners. And Mrs. K. Gogoi and the CGC appearing for the
I am for one and two lordship.
respondent number 1
And two lordship.
and 2. And Mrs. A. Bora, Leonard
Deborah,
D. Bora.
Deborah.
D. Bora, Leonard standing counsel for the
Health Department.
Health Department, appearing for respondent number 3. So you'll be for 1 and 2.
Lordship, I am for one and two.
1 and 2.
Ministry of
Okay,
Health
one, three.
Union.
Next para. The case of the petitioner is that petitioners is that the petitioner number 1 has crossed the upper age limit of 55 years. Which has disabled him from undergoing IVF as per section 21 within brackets small g of the assisted reproductive within bracket regulation bracket close act 2021.
Even lordship, surrogacy regulation act also lordship under section 4T CZ lordship.
Okay, the Leonard CGC has submitted that
Lordship,
Even-
I pass on.
under the surrogacy act.
Lordship,
Just give me, I don't need it, just tell me. Surrogacy act, comma. Which year?
2021 lordship. Surrogacy regulation act 2021 lordship.
Surrogacy regulation act 2021.
Lordship. Under section lordship 4 Roman 3 CZ lordship.
Roman 3 is small Roman 3.
Lordship, lordship.
4-3
CZ lordship. C
C
CZ.
G. Okay. Sorry,
C1 lordship, C1 lordship, C1, not 0, C1.
just give me.
C1.
Confused.
Z is in lordship, that regulation.
Hmm?
Z is lordship in the assisted reproductive technology regulation.
Yes.
Yes, C lordship.
Very confusing. 4 within bracket. Small Roman 3. Then again B, small b. No, not B, C. And then
Roman 1.
capital Roman 1.
Lordship.
Surrogacy, SURRO, GACOY. GACY within bracket regulation, Act 2021. Stop. It is also submitted that the issue raised by the petitioner is pending for adjudication before the Supreme Court of India, being so and so versus so and so, WPC 52220-23 of this is our last year 2022. 22.
Last listed lordship.
No, 52220 of
Lordship,
dash 23
Lordship.
is of which year? Of
23 lordship.
23.
Lordship.
And case of so and so, WBC so and so. So it is submitted that the matter was last listed on 16/5/2023. And the matter is still pending. Next para, be that as it may, issue notice of motion returnable in 3 weeks. Requisite extra copies of the writ petition be served on at CGC and the Department Council in course of the day. Next para, the pendency of this writ petition shall not be a bar for the competent respondent authorities to examine the claim of the petitioner.
Lordship.
Whether interim, I require interim in the nature, I may be allowed to lordship.
Lordship,
Proceed.
that petition,
Then the petition is what you call, there is no further order to be passed.
even honorable apex court also, there is that injunction petition also
In
there,
that
that
case,
was also
lordship,
negated.
the acts were challenged as ultra vires, lordship. I have not challenged the acts, lordship.
No, it's not a question of act.
Lordship.
You see, if that act is a valid piece of legislation, then you can't do it. Then the court would not have power to give any opinion when the matter is before the Supreme Court.
Then your lordship, in that case, they have already filed affidavit of opposition, so later maybe fixed after 2 weeks, any date, lordship.
For 3 weeks, he is not filed it here.
No, he has.
I
filed
can't
it.
fix a date in the Supreme Court.
No, lordship, that.
Lordship, I will try, in the
that
meantime,
fixed-
Lordship, I will also file affidavit in this case also, Lordship, in the, within the 3
You see, otherwise also when the matter is pending before the Supreme Court of India, we will not adjudicate it. Your matter has to be deferred. You should not be in a false hope that when the matter is pending before the Supreme Court adjudication, then we'll take up the matter and dispose it off. That we perhaps not do. So don't be in a false hope.
Date fixed, lordship.
When the issue is pending before the Superior Court, we are not, we can't be called upon to take a decision. Yes,
After
69.
lordship. Date, lordship.
69,
give a date after 3 weeks.
26/6.
69, yes.
69. এখন 8 হয়ে গেল, May I please, Your Lordship? My lord, what had happened in this case, my lord? We are having a cement factory over the schedule A and B land from 2008, my lord. My lord, all of a sudden on 28,
No, that I
4/23.
remember. I remember.
Yeah.
You have instructions?
Yes, my lord, I have not received any instruction, my lord.
That is a difficulty. You,
My lord,
You
my
stop it and
only
then-
submission was like this, my lord. A private party has intervened. They would like to say a particular plot of land which belongs to them according to is a part of the Schedule A land. My lord, if you are a patadar of that land, you have your remedies elsewhere. In my writ petition, you cannot come and set up a plea. If you feel that your land has been encroached by somebody else, my lord, there are forums to hesitate those, grievances. Now, here in this case, my lord, I am an operational factory. Now, if your lordship kindly goes to the earlier order, my lord, which was passed by this honorable court, I'm not even seeking anything more than this, my lord.
page 338.
Yes, my lord. In the IA, it is annexed, my lord.
Page 338.
I will be separate.
I is separate.
Please come to page 14.
Page,
Michael order. I'm sorry, my lord. IA number 1278. If your lordship would kindly come to page 16 of that order. 17 rather. On 4/5/23. I'm reading the bottom two lines. Mr. R. Borpujari, Learned Counsel, appeared for the respondent number 1. And Mr. K. Goge as well as N. Goswami, Learned Counsel, appeared for respondent number 2 to 4. They submit that petitioners have illegally occupied the government land adjacent to the land owned by the petitioners by way of encroachment. Accordingly, construction made over the enclosed area of land have been demolished. They further submit that no demolition will be undertaken on land covered by Schedule A and B. So we are asking that at A and B, my lord, we should be allowed to operate because in between they have put up a barricade. At page 249, we have indicated. Now kindly see, on considering the submission made by the Learned Counsel for the parties and on perusing the documents on record, respondents are directed not to take any action in respect of any construction made by the petitioners on land covered by Schedule A and B to the petitioner. So this honorable court has protected us. Only thing is, my lord, they have what they have done. If a lordship will kindly come to page 249, my lord, of the writ petition. 249, my lord. Now they have put one, my lord, barricade saying Sarkari Bhumi.
just a moment.
249, my lord,
Of the writ petition.
of the writ. This is what is coming in the way, my lord, of operating the factory. My lord, lordship knows the production of cement is a integrated process, my lord. The limestones are there in the Schedule A, B land, my lord. And the factory continues up to Schedule A land. In between, there is a conveyor belt. Now, we can't even bring our limestone from, my lord, for the purpose of producing in Schedule A land. Now, my lord, the problem can be solved this way, my lord. Let there be a survey. Let us continue, my lord. Tomorrow, if they can show that we are within the Schedule A and B land, where occupation of any government land, then let them identify, we'll take steps, my lord. Otherwise, we'll wind up this factory and we'll go off, my lord. But for the present, let us do, my lord. And in any case, my lord, under section 162(4) of the Assam Land Revenue Regulation, even if, my lord, a tribal belt land is being occupied by a non-tribal, then for the purpose of industry and all, government has been given some power. We'll approach the government. If your lordship would kindly come to page 162 for a moment, my lord. 162. Oh. What is the original chapter 10? Oh. 162. Even Kibadi. That no, 160 government of power to the asset. My lord may kindly come to 162, my lord, section. (162), it starts with extension of chapter 10 to such areas. Please come to subsection 4, my lord. State government may in the like manner direct that provisions of this chapter shall cease to apply to any area or areas or provisions of any area or areas to which they have been applied under provisions of subsection 1. My lord, in my humble understanding, my lord, chapter 10 is not prohibitory. It is only regulatory, my lord. It will be wrong to say that a non-tribal cannot acquire land in a tribal belt. It's a regulatory provision, my lord. And my lord, the industrial policy of 2008, which the, my lord, state is pursuing, that we have annexed in page 27, my lord. Kindly come to page 27, my lord.
(27) of the writ petition.
27. I will build Kindly see, my lord, para 57. Industrial Policy Assam 2008. In chapter 8 provides for special incentives for mega projects, and clause 8(1) and 2 of this 8 policy are as follows. 8.1. Projects with large capital investment with a minimum of rupees 100 crore or generating minimum of 1,000 regular employment and having potential for development of ancillary industries based on census. My lord, we are paying 83 crores of revenue annually to the government. 83 crores of revenue direct every year, my lord, as of now. And we are operating from 2008. So nothing is going to happen, my lord. Let there be a survey. Let them point out this is the land which is government land, my lord. Then we'll take a call. But who is gaining by stoppage of this, my lord? There are a lot of modern employment. 6,000. My lord, direct and indirect employment is 6,000, my lord. Government has taken enough time for the instruction, my lord. Also, will kindly see. So what I am praying for is, my lord, let there be a survey. Let us operate, and subject to, my lord, further orders.
The last day, my lord, 2 days back, my lord, when the guy was confirmed, I have already informed that we need some time, my lord. They are preparing, my lord, to complete their was comment, my lord, for heading us, my lord.
Okay, yes,
Yes, my lord.
Mr. Chaudhary.
Well, I file an affidavit, my lord.
Yes,
First thing is that, my lord, your lordship kindly go to the, my lord. As order passed by the, my lord, Honorable Justice, my lord. A Bujal, my lord. In this case.
affidavit in opposition by
Yeah.
Mohan Singh Rompi.
Yes.
Yes,
Your Lordship, kindly come to the my lord,
Just,
annexer B, page 304.
just a minute.
Yes, my lord, page 337, my lord,
Page
337.
P37.
Yes,
Yes,
my lord. Relevant portion is, my lord, 341.
yes.
Accordingly, have you lordship got it, my lord? Accordingly, the petitioner or the authorized representation to, this is for Purbanchal Cement, my lord. He is appearing in this case, my lord. An order has been passed. Accordingly, the petitioner or the authorized representation to appear before the circle officer Sunapur Revenue Circle on 19/9/2022 at 10:30 AM. On as appearance, circle officer shall provide the petitioner is authorized if they required document they may desire to form their objection on the said, shall also inform the petitioner representative about the document in their possession, which the circle officer may acquire, according to the petitioner to file their objection, if any, and thereafter appear again on 10/10/2022, from which the actual proceeding before the circle stated, same be brought logical within a period of 2 months thereafter. In the hearing, circle also inquire of the complaint of Monsing Rongpi, that this land was purchased by the registration cell number so and so, is presently being owned by the petitioner Purbanchal Cement Private Limited. The circular upon perusal of the record shall form an opinion as to whether the purchase of modified registered deed number so and so had legitimately owned and possessed by the petitioner, and if to take appropriate action under the law. The conclusion of the circle officer may arrive inform the deputy commissioner shall initiate a civil or criminal proceeding, as the case may be both inquiry, complicity, any illegal and a criminal act done by any parties. By thereafter, my lord, he has not produced not a single document before the circle officer, my lord. Reason behind it, there is a reason, my lord, because this, of course, my line of senior friend is not available. Most of the document is forged and fabricated. And this has been stated in here also, my lord. That is why he is not producing any document before the circle officer, my lord. Page 305, my lord. First 305, my lord. 304 is the report on the basis of that clarification certificate. 305, my lord, has come, my lord. This is on certified the sub-register Kamrup Metro District. Clarification date regarding the deed number Deva Bhattasai purchaser. However, it claimed that though the inquiry search, no such deeds are found to be executed in senior sub-register Kamrup Metro. That Devakumar Bhattasai and Dhiren Bora did, my lord. That was not, my lord, executed. On the light of the above report, sub-register, the purchase of the land as claimed by the Purbanchal Cement stand to be false. As no certificate with regard to illegitimacy, Dhiren Bora has been submitted in the office hearing as per direction honorable court in 4761/2021. That petition number, my lord. I have read the Honorable Justice A. order, my lord. 2021. The land being covered, chapter 10, Assam Land and Revenue Regulation, prerequisite of being eligible to hold the protected bail and block. Eligible Pattadar need to be clarified in the matter. Question Dhiren Bora or Purbanchal has not been substituted any document to assert in his case till date. Next, my lord, Monsing Rongpi, they have written sub-register. With reference to the subject, I am to inform that I have the available record maintained regarding the, it is seen the cell deed number, serial 25313, annexer, my lord. Annexer 30, 32 and 38 of the
Yes.
writ petition, my lord. This
Page,
certificate has
page.
been given. Earlier, this has been given.
Page.
Right.
Page.
Annex, I am reading para 306, annexer D of the affidavit in opposition.
306, yes.
Yes, my lord. With reference to the subject cited above, I am to inform that as per available office record maintained regarding register, it is seen that cell deed number to so and so, so and so, so and so, so and so, and so and so, so and so have not been registered in the office in the name of Northeast Power Limited and McGill Project Private Limited. I want to say, my lord, document 30, annex 32 are all are forced document, my lord. On the basis of that petition has been filed, and they are claiming that this is the patta land, my lord. That is not available in the record also, my lord. Then, my lord, your lordship, on page 307. Interesting thing has been done in the instant case, my lord. Here, my lord, permission has been asked by Lasit Bosumotari and Parsadar is Thornbay, my lord. Have your lordship seen 307
Yes,
annexary? And if you go to the, if your lordship go to the page 198 of the writ petition, of the writ petition, Lord, you look at that, my lord. They annex 34 of the writ petition.
yes,
Yes, my lord. Memo number KRS 921/2011/16. Dated 13/1/2020, my lord. Number 2, McKill Project Private Limited. Have your lordship, and your lordship look to my annexer, my lord. Hornby. This is the, my lord, certificate, my lord. We have taken certified copy. I want to say, my lord, this writ petition is liable to be dismissed in limine because patta land which has been shown, all the document are forced document produced before the court, my lord. On the basis of that, this petitioner is asking the relief, my lord, whether that is permissible under the law, my lord. And one thing is important, my lord, because this case is going, my lord, because Poddut Bora case, last time I discussed, I have annexed this. This list is into that Poddut Bora husband, my lord. Any land, not said, my lord, government land or private land, if the people of non-tribal people holding, uses, possess, and own the particular land, then that should be evicted, my lord, immediately. And this interim order, which has been contrary to the order of the Poddut Bora judgment, my lord. And for that reason, there is a date has been fixed by the, my lord, Honorable Justice Ujjar Burua, to do all these things. But I am very sorry to say, government also not doing anything, my lord. Because there is a reason that they are big industry. We are the small tribal people, my lord. So government has not done anything, my lord, to do all these things, my lord. So, my lord, my humble submission before your lord, whether it is a government land and whether it is a patta land, my lord, that has to be ascertaining. First, my lord, they have produced the document which is forced, apparently forced, my lord. I have produced before your lordship the certificate. On the basis of that, they are asking for relief, my lord, whether it is permissible under the law. And so far, second part is concerned, my lord. As last time, my lord, my landed friend has sold one judgment, my lord. Your lordship has gone that judgment. I have annexed that judgment, my lord. In respect of rule 18.1 and 18.2, my lord. Your lordship, the notice is not required for evicting them from the government land, my lord. That is the thing. My lord,
Mr.
reply-
Chaudhary,
Yes, my lord.
where is the prayer that he wants to reside in the government land? Where is that prayer?
My lord.
No, Mr.
Yes, father.
NNV Chaudhary. I have to be cautious when it is Chaudhary versus Chaudhary.
Yes, sir. No, it is prayer, my lord. I am
Chaudhary, my lord. I am KNC.
My lord, this is an affidavit in opposition, my lord. I have filed, my lord.
No, that is okay.
Yes, my lord.
But you see, I am asking you a question with relation to the prayer made in the petition. My question is that you have said so many things, but what is the nature of prayer made here?
Yes, yeah, my lord, it is an affidavit in opposition filed by me, my lord. I have stated all these things, my lord.
No, that is not what I am saying. I am saying that whatever submission you are making
Yes, my lord.
must be with relation to the prayer made in the petition. What is the prayer in this petition?
Prayer of the petition, my lord.
Hmm.
It is, the Your Lordship, say, admit this petition, call for the record why the right, carried out by the respondent supervision of the circle officer, so should not be adjudicated as null and void. And why the respondent should not be directed to remove bamboo fencing from the entry point of Schedule B. That circle officer which has been carried out, my lord, should be adjudicated null and void. That order.
Correct.
Yes, silence,
So
my lord.
either your case would be that in guise of evicting him from government land, what the respondent is doing is evicting him from a tribal belt land.
Yes, my lord.
That is your case.
My lord, my case is there, my lord, this industry cannot.
No, that is different.
Yes, my lord.
For that, you will have to present your own petition.
Yes, my
We are
lord.
now hearing on the petition by Mr. K. N. Chaudhary.
Yes, my lord. One
Correct.
thing is that, my lord.
The question is, that if you take a clear stand that no, actually it was a tribal belt land, and therefore by way of a government land, in the guise of evicting him from a government land, actually we are evicting him from a tribal land. If that is your case, you'll have to say that. If it is not that case, so you see, even a trespasser has a right to.
Come to read, my lord, my petition, my lord, page 274, my lord.
Is 274.
Yes, my lord. Affidavit in opposition, my lord. 274. Your lordship, got it?
274, yes.
274. Your lordship, kindly read, my lord. I am reading paragraph. Deepanand further stated, even assuming not admitting, if there had been any rectification also for approval of the necessary, no such approval has been submitted. Therefore, the said NOC is forced document, hence the count of the is liable to be dismissed. Next slide, ma'am. Land described in Schedule B of the writ petition land fall under non-cadastral villages, and which is not surveyed till date, but the petitioner by manipulation of record has filed test map on non-cadastral land, which shows that petitioner has resorted illegality and filed the instant case, which document manufactured by force and fabrication. This is my prayer, my lord.
That's okay, you see.
Yes, my lord. Moment
Then-
your
then-
lordship
then-
has
then-
passed an order on the basis of schedule submitted by my learned senior friend, my lord. Yes, my lord. Then on the grab of that order, my lord, they have acquired all this land also, my lord. Government land as well as this land. Because one proceeding is running, my lord, on the basis of order passed by the Honorable Justice Bujar on the.
See, Mr. Chaudhary, you're still not answering my question. You see, we must understand the contours of the writ petition and then proceed with the hearing,
Yes, ma'am.
correct?
Yes, ma'am.
Can I start a hearing by taking note of the affidavit and then questioning the petitioner? Can that be done?
If, my lord, I say, my lord, document is forged and fabricated, and on the basis of that document, my lord, the
Okay,
petitioner is
okay,
asking.
we'll come to that. You see, you say that you are forged, the document is
Yes,
forged.
my lord, this is the.
Are you,
request.
are you an authority under any act to say
I
that?
am not the authority, circle officer, the authority, I produce the
Is,
report.
can circle officer declare anything to be forgery?
Yes, because sub-register office, that document is not available, my lord.
Mr. Chaudhary, this is something I never expected from you.
I know, my lord, your lordship is asking that it is declared by the civil code, my lord.
No, I'm not asking you that. I am asking you which are the authority prescribed by law to declare anything as forgery.
Yes, my lord.
If a circle officer says, and if you accept it, we'll record that submission.
Circular officers say that this document was not registered. So on the
No,
basis of
you
the
see-
report of sub-register.
You see, Mr. K. N. Chaudhary's client may be a worst man in the earth,
Yes, my lord.
correct? But can you, but the question is, when he is seeking a remedy that except for the government land, he will be allowed to enter his land. Until and unless somebody declares it to be a forgery and saying that this land is not his. How can a writ court interfere?
I want to say this document was never produced before any authority. That is why I am reading the Honorable Justice Osinta Malla Bujagura order. Because they are not producing, first time they produced before this court, my lord.
Correct.
High
So,
Court,
so
my lord.
it is your submission as as an officer
my
of the
lord.
court,
Because he has got opportunity
as
to
an officer
produce
of
all
the,
this
no,
document.
as an officer of the court, it is your submission that when when the petitioner is agitating the right to enter his land, correct, he will have to disclose all the documents to all the authorities like circle officer, like a sub-registrar, so and so to make that prayer.
No, my lord, I am one who come to the court, my lord, come with clean hand, my lord, for filing the writ petition. He get an opportunity to produce all the document before the circular, not producing that document.
What is this,
Reason is that
Mr. Chaudhary? You are avoiding that question. I'm time and time asking you. What is this circle officer doing? He is investigating encroachment to a government land, or he is making an inquiry with regard to a private land. Please be sure about it. What is your statement? I am asking you again.
my lord, that
The
answer-
inquiry by the circle officer
Yes, sir.
was in respect of a government land, or it was an inquiry with regard to the private land.
My lord, as per this, my lord, the inquiry to the government land, your lordship is correct.
Then why
So far
should,
relating to private land is concerned.
why is he
I am
required?
coming, my lord.
No, why is he required to show to the circle officer a private land document when the inquiry is with regard to the government land?
No, my lord, when we ask the circle officer.
No, you may ask for so many things. You may
Yes,
ask
sir.
for the moon,
Yes, sir.
but what is the nature of inquiry by the circle officer?
The circle officer said on the basis of report of sub-register that this document was not registered.
Okay.
Anyway, my submission, this document is a forced document.
No.
Who is not my
where is- Mr. Chaudhary, where is the circle officer's notice of eviction?
Yes.
Where is that?
No notice, no notice. All of a sudden they came on, my lord, 28/4/2023.
Okay, where is that statement?
Yes. One second.
Oh, para 33,
Para 40, my lord.
para 33 also.
Yes,
Refuse to
33
show.
also, yes.
33, yes.
At 10:30, circle officer came to the factory premises of petitioner along with 5 number of JCP, 1 so and so, 5 number of along with so and so, fitted with mounted ladder and 50 armed force and forcibly and illegally tried to enter the factory premises of the petitioner, and then Amrit Singh requested the circular whether there is any notice on any provisions of law. And the ejectment from the land, the said circle officer replied to Amrit Singh, there is no need to issue any notice for doing the eviction from the government land, and on this, inform the circle officer, the petitioners are not in possession of the government land and factory premises and its allied structures like fly ash, shed, godown and other structures standing over patha land of the petitioners. But the said officer replied to Amrit Singh that there is no any order by DC Kamrup for eviction of the petitioner from the government land and for demolition of the structure constructed over government land. But Sri Amrit Singh requested circle officer to show the order of the DC Kamrup for demolition, but circle officer refused to show any such order. My learned friend claims that his client has 15 bigha, but our factory is over 131 bighas of land. I mean, if it is his case, this patha land is being encroached by us, let him go to civil court, my lord. How as an OP, he will come and set up a plea in my petition. My lord, in this Sonapur tribal belt and block, my lord, few land mafias are operating, my lord. They're exploiting these tribal people, my lord, and my lord, from time to time for their personal needs, they intervene in these proceedings like this.
I may not like to
My lord,
go
no,
outside
my
the brief.
My lord,
the difficulty is-
there are, we have come across, no, my lord, my only prayer is, let the whole land be surveyed. Let us start our operations, my lord. Tomorrow, if they can show that this portion is government land or this particular plot of Miadi Patta land does not belong to us, then they can always take the action, my lord. Now, what is the basis of taking action? At least, my lord, we are running a factory same from 2008. Could be, my lord, there could be some portion of, we are not disputing that. But there is a manner by which you can take the action.
Okay, they're passing an order.
My lord, one judgment, my lord, to that aspect, my lord, 1988 to GLR, my lord, paragraph High Court versus S. Zahan. He is suppose assuming but not admitting. His my
1998,
1988 to GLR 9. Para 18. My lord, with lots of kind permission can I take? 1988? 1988 Dada Hari 2 GLR. Okay. Nine. My lord, paragraph 18.
Just a moment, I'll have to take 2 minutes time to find it out.
Says, para 18 and
Yes.
22, my lord.
Yes, please read that.
Yes, my lord. So far as the question that one decided cannot be reopened, we may again point out such point was not argued before the learned Board of Revenue. Even otherwise, we find that court has repeatedly held that case where land cannot be alienated to all stand on a different footing, the revenue tribunal cannot validate sale. So and so reference be made in AR 1950, Assam 40, Narayanpur, Damrup Burgohai, Assam, even in the absence of the decision, we are opinion that when a statute exclusively prohibit any sale, exchange, any sort of transfer, alienation by the tribal to non-tribal in the tribal, in a tribal area, then any transaction to the contrary is void ab initio. Neither there is any limitation nor requirement law for getting it declared the process in the court of law.
Okay.
Yes, my lord. And next paragraph 22, my lord. The learned council invited our attention subsection 3 of section 1 to argue the said to introduce amendment.
Okay, I've taken note of that.
Yes, my lord.
I've taken note of that.
Yes, my
Okay.
lord.
Heard. Mr. K. N. Chaudhary, learned senior counsel, assisted by Mr. R. J. Das, learned counsel for the petitioner, and also heard Mr. M. Chedia, learned government advocate, appearing for respondent number 2, 3, and 4. One, Mrs. G. Hazarika, standing also for respondent number 1, and Mr. NLB Chaudhary, learned counsel for respondent number 5.
my lord.
Next para. At the outset, the learned government advocate has submitted that he needs some more time to obtain para-wise comments and to file an affidavit in opposition in the matter. Next para. The matter is listed today pursuant to order dated 25/5/2023, where this court was inclined to provide that if the matter cannot be heard on the next date, the prayer for interim release shall be considered. Most of the matter was listed on 31/5/2023 and could not be taken up and therefore listed today. Next paragraph. Accordingly, the prayer for interim relief is taken up. Next paragraph. The learned senior counsel for the petitioner has submitted that as the petitioner has a running industry over the Schedule A and B land, at this stage his prayer would be to direct the circle officer Sonapur Revenue Circle to carry out a demarcation of the government land, if any encroached by the petitioner. And he submits that insofar as the other land is concerned, which is not a government land, there may be no impediment for the petitioner to resume the industry. Next paragraph. Per contra, the learned counsel for the respondent number 5 has referred to various documents appended to the writ petition as well as the affidavit in opposition filed by respondent number 5. And it is projected that the petitioner has usurped the land of the respondent number 5 by means of using forged and fabricated documents. First, it is submitted that the so-called sale deeds executed by the purportedly executed by the respondent number 5, were not found to be existing in the office of the sub-registry. Hence, it is submitted that as the writ petition is based on forged and fabricated documents, the petition is deserved to be dismissed. By referring to the decision of the division bench of this court in High Court, son of SO, is son or S of the go, Jahan, JAHN, and 25 others versus Assam Board of Revenue and others, within bracket 1988, bracket 2, bracket equals 2 GLR 9. It is submitted that there is a statutory prohibition in the transfer of the alienation of land in the tribal belt by tribal to non-tribals, and that any transaction to the contrary is void. And in this regard, reference is made to the provisions of section 162 of the Assam Land and Revenue Regulation, 1886. By referring to the judgment and order dated 6/9/2022 passed by this court in WPC 4761 of 2021, it is submitted that as per directions contained in paragraph 10 thereof, there was a requirement of a circle officer to make an inquiry about the documents of the petitioner in respect of the land on which the industry was set up. First, it is submitted that despite the said order, the petitioner has not produced any document of title in respect of the land occupied by them. By referring to the order of this court in Order dated 3/3/2023 passed by this court in WBC 1156 of 2023. It is submitted that for eviction of the petitioner from a government land, no notice is required to be issued. Mrs. Chaudhary, this judgment at page 321, you are citing for that purpose only?
Yes, my lord.
Okay. What other,
For evicting the government land under their rule 18(1).
Rule 18(1) and 2. Okay, rule 18(1) 2 of the rules framed under the Assam Land and Regulation, 1886. Next paragraph. The prayer made in this writ petition is as follows, page 28, flag. Pink flag. So based on the prayer made in this writ petition, the court is of the considered opinion that the issue raised by the petitioner is limited to the extent that the respondents should be prohibited from interfering in the running of the cement factory of the petitioner number 1, which is standing over the plot of land described in described in Schedule A and Schedule B appended to the writ petition. Full stop. Therefore, in a writ petition where the query is to the extent of permitting the petitioner to operate from Schedule A and Schedule B land, the court would also only have to examine as to whether in the gap of entering into the plot of land described in Schedule A and B, or whether the petitioner shall resume operations on a government land. The court is conscious of the fact that the allegation in this writ petition is to the extent that without issuing any notice, the circle officer along with police force had entered into the factory premises of the petitioner and evicted the petitioner from the government land by demolishing structures which were standing over the government land. Next paragraph. Insofar as the claim of the respondent number 5 is concerned, to the effect that the land of the respondent number 5 was illegally usurped by the petitioner to set up his factory, there can be two inferences which can be drawn up. Firstly, that in garb of evicting the petitioner from the tribal land protected under chapter 10 of the Assam Land and Revenue Regulation, the circle officer had carried out eviction of the petitioner in guise of removing him from government land. To stop. The second possibility is that instead of evicting the petitioner from the tribal land, the circle officer had used power under section 18(1) and 18(2) of the rules framed under the Assam Land and Revenue Regulation to evict the petitioner from a purely government land. Full stop. Under both circumstances, if the petitioner has, if the respondent number 5 has any claim of ownership of the land allegedly belonging to him, it would not be open to the respondent number 5 to agitate the said claim in a writ petition filed by the petitioner. In the considered opinion of the court, any claim which the respondent number 5 might have against the petitioner has to be adjudicated in an appropriate forum. Full stop. It is not the case of the circle officer till date that he was evicting the petitioner from a land under the tribal belt. Full stop. If that was the case, then the circle officer would have given a notice to the petitioner as envisaged in law. And the provisions of order of section of rule 18(1) and 18(2) of the rules framed under Assam Land and Revenue Regulation 1886 would not be available to the circle officer. Full stop. Next, under such circumstances, the court is disinclined to take cognizance of the allegations of the petitioner that the land documents which are for the purpose of interim order, the court is disinclined to take cognizance of the stand taken by the respondent number 5 that the land documents produced by the petitioner in respect of where in fact those documents of the land documents of the respondent number 5 for two reasons. Full stop. Firstly, that no competent court having jurisdiction has declared the documents to be forged. Full stop. Secondly, without a declaration being available as to the forgery of the said documents, this court, in exercise of jurisdiction under Article 226 of the Constitution of India, would not enter into a disputed questions of fact. Full stop. Therefore, as indicated earlier, the respondent number 5 would have to agitate his grievance, if there be any, before the competent forum. And the pendency of this writ petition shall not be a bar for the petitioner to do so, to respondent number 5 to do so. Next para. Insofar as the prayer for interim relief is concerned, as the case of the petitioner is that he was evicted from the purported government land without issuance of notice, the court is inclined to provide that the petitioner shall appear before the authorized representative of the petitioner shall appear before the circle officer, Sonapur Revenue Circle, with a representation to have the demarcation carried out in respect of the government land allegedly occupied by the petitioner for his cement factory, and we said demarcation be carried out within a period of 21 days from the date of receipt of a certified copy of this order. First of all, the period of 21 days is provided. Taking into consideration the claim made by the petitioner that the factory land is over 130 bighas of land. Full stop. Further orders on the interim prayer shall be passed on the next date on receipt of a report from the circle officer on demarcation. Next paragraph, the the petitioner shall produce a certified copy of this order before the circle officer, Sonapur Revenue Circle, within a period, along with his representation as indicated above. List on after 4 weeks, give a date. After 4 weeks, it will be vacation. It will be listing on
19/7.
26, 27,
no 21 days. We are giving today's second.
second, 20,
It will come into the last date
20.
20,
23. You make it 26.
23rd June.
Yes.
Well, there is a proceeding is going on by the order passed by the Honorable Justice Rizal Bura, my lord.
Okay.
In
that's,
that proceeding, they produced this order, my lord,
Yes,
and saying to pull all the cell did, my lord. That is the way.
No,
This is-
that will not do that. I just say this order shall not shall not have the effect of overriding the the order dated 6/9/2022 passed in WPC 4761 of 2021 or judgment and order dated 3/3/2023 passed in WPC 1156 of 2023. And shall not dilute. And shall not dilute the order is so and so.
Deeply obliged.
What's it, the next date is 23rd June?
Deeply obliged.
RT1 for admission.
Yes, Mr. Das.
Investigation team was formed for the purpose of looking into this complaint, FIR, dated 2016, whereby petitioner husband was kidnapped on political reasons. The SIT report, my lord, first report is all right, but the second report given is in the very deeming manner.
What is the second report dated? Second report is dated
Dated, my lord, it is
26/7.
received on 8/5/23. It is dated 24/4/23.
Just a
It is
moment.
as if nothing is there. But earlier order there.
No, just a moment. I did not find that.
May I provide with you?
No, maybe, but just let me find out.
Earlier order, they say, my lord, they have,
Just, Mr. Das, you have an extra copy of that.
yes, provide.
This never came to my notice.
Earlier order, my lord, it looks like when some work has been done. So this is on political ground, my lord, he was kidnapped. Not to allow the petitioner's brother to vote in the North Kachar Council, non-competent motions.
So it's not been recovered till date.
Body not recovered in 7 years, I don't think body will be there, but they should take action against some persons who were available and who were arrested. They should investigate and conclude it. Political reasons are there, that is there, my lord. Even the same CM continues to be the CM of the council. And it seems, my lord, it is very difficult. Either if the special investigation team is failing to do, the matter should go to CBI or CID, my lord. This woman, my lord, petitioner,
Correct,
she
correct.
should get justice.
Correct. Yes.
Correct. The last report has been submitted before the court. That's the report dated 24/4/2023. So we have placed it by way of an affidavit. So ultimately, the reports, some substance of it that the person could not be traced out in spite of 2 mobiles being tracked and their IMEI numbers being tracked, and nothing has been identified. 2 persons has been interrogated, the persons suspected people. But the whereabout of the
No, you see, Mr. Das is very right in saying, if you have not found, you give a closure report.
that's true.
Yeah, otherwise the victims are, they'll always be in trouble.
Earlier report, affidavit, if your lordship looks into, that is very encouraging. In fact, they have done some more. Then thereafter, my lord, nothing is there. What they have arrested some people, collected some evidence. Then thereafter, my lord, what is it? And means persons were arrested also, my lord. Earlier, they were roaming around in the town itself. After filing this petition, my lord, they were arrested. And they have gone on bail. That's a different matter. But what has happened to the investigation, ma'am? It is not about finding of the
Dead
body of the victim.
Body of the,
It is something else also. My lord, the petitioner is, my lord, hoping that the persons who were
okay, we'll provide that. Heard Mr. Viridas and the senior counsel, assisted by Mr. D. Land counsel for the petitioner. And Mr. S. Barwal, government advocate appearing for the respondents.
the senior
The
officer
court,
may look into the matter.
the court finds force in the submissions made by the senior counsel for the petitioner that the police police personnel who are investigating DIYUNG MUKH ES case number 3 of 2016 should bring the investigation to a logical conclusion. Full stop. Next paragraph. The status of investigation carried out so far is not culled out from the status report dated 24/4/2023 produced by the learned additional senior government advocate.
There is also there.
Yes, Mr. Barwa.
Yes, there is another additional affidavit bringing on record the status of the investigation which has been carried out. That has been filed by the additional superintendent of police. So here also he has enumerated the level of investigation and the person who has been summoned and examined. So these details are in this affidavit and the other.
Which affidavit? Because it's not here.
Yeah.
Which affidavit you are referring to? When filed when?
February 28, 2022. This is the previous one, the earlier one.
No. What Mr. Das is producing is a part of your affidavit of 12/5/23.
Yes.
I'm referring to that
of,
only.
this particular year, that is of April. And the other one, this is the initial affidavit that has been prepared by the superintendent. So here he brings out the details of the investigation which has been carried out.
Which report your lordship will kindly see, we have received a copy on 2/3/22. That affidavit your lordship will kindly see. Lastly, they say
the case is now pending for arrest of main suspect.
Huh.
Monjoy, Nunisa Temper and two other suspected, namely so and so and so and so, and recovery of the victim.
Mr. Barwa, you will tell them, you see, when they're sending a report, they must send a gist of investigation which has been carried out. Correct. It is always open to you to tell the court that it may not, since it may hamper a investigation, it may not be made a part of
Correct.
record. So that what happens is that we peruse the record and send back it to you.
The confidentiality is.
If you think it is confidential.
Yes.
But the nature of what you call report which is now being given is nothing confidential about it.
There is nothing confidential.
So if you see, always when you produce a status report, you can always make a prayer not to make it a part of
Yes,
record, so that
definitely.
it goes out
That
and
has to be in the greater interest, yes.
no, but if you see, interest is only to prevent what you call the leakage of confidential
Yes,
information.
that's right.
But I don't think after 7 years,
Yes.
any confidentiality remains.
That's
So therefore, you have to give a gist of what investigation has been done. Not the entire case diary, but the gist of investigation must be there. So next time when you are producing it.
Yes.
And that's why we are making that statement.
Like the previous, that's why I was referring to the previous affidavit. So here they have detailed the level of investigation that has proceeded one after another. So, and after that follows up this affidavit. So here.
No,
the
it's
report
okay. You see, Mr. Das is very candid
Yes,
about it.
is-
He said that if you don't have done
close
investigation,
the-
close it.
Yes,
Because
Ultimately, it
right,
has to
ultimately the people for whom Mr. Das is representing are anxious about it.
very true.
Correct. They made the investigation. If there's the investigation is carried out, if you arrested someone, you could have sent it for trial.
Yeah.
If you have some material, if it was, you see, the last seen theory is there. So this theory, even if a dead body is not found,
That would is. not-
still there can be a investigation carried out.
Not only dead body, my lord, the persons who are involved. Persons who are there, my lord, arrested and all those
No,
things.
Mr. Das, what happens is that what is the term I forgot? Latin term I forgot. Because if there's a death, there must be a dead body.
Yes.
So what is that
But
called?
now it is 7 years.
Body
maybe, my lord.
derelicto or something.
Yes.
I found.
Even,
There's some term I forgot.
yes.
But so far, my petitioners are concerned, my lord. If the wife, her husband has been kidnapped, he wants justice. And
No, that
she
is okay,
thinks,
that's
my lord,
fine.
it is 7 years. He thinks, my lord, the police is capable of giving her justice. Not only the body is a different matter, and the body may not be there. 7 years, we know about it, my lord. But what about the persons who have really picked him up and then thereafter threatening that.
No,
you
that's
don't
why
send your gun.
investigation must come to a conclusive.
Political things are there, we have said so. So let them show that they are expert in finding out this. My lord, they should show, my lord, they are showing their.
No, correct.
They are
That's why I
showing
have
their,
explained
my
to
lord,
That's why I have
expertise
explained it to you.
elsewhere.
What did I say last para? Investigation. I started investigation in a seal cover for the perusal of the court. Indicating the names of the suspected accused and the nature of investigation carried out so far.
And when the same is likely to be completed.
That we can't say. That we can't say. The report be routed to the office of the senior advocate, the senior government advocate, Guwahati High Court. Next, the learned government advocate shall transmit a downloaded copy of this order to the Superintendent of Police, Dima Hasawa Haflong. Next, list on. How much time? Sabarwa?
That would be 4 weeks.
After the vacation, man.
After the vacation. 19/7 then,
Yes.
Mr. Das, this is, you produced it, this
Yes.
one.
Obliged.
Let's see who's this is, huh? That's one.
Party to.
Yes, Mr. Siddharth.
My lord, here in this case, my lord, the petitioners on a prevention of eviction, they have filed this case, my lord. They are on the, admittedly, they are on the government cash land, but the railway claiming that the land is the railway land. My lord,
Yes.
here, my lord, some another analogous matter is pending, and except 6 page 44 on the same issue. And sir 6. And they are residing on the same land. These people were earlier issued notice, and this petition number 5866 2015.
You see, it's a railway land. Railway doesn't own a land. Therefore, the railway must have acquired it by public, what you call the acquisition process. It can't be allotted to you. The reparation has to be dismissed.
They acquired, my lord, then we'll face that, my lord.
No, no, no. That is not the prayer. You see, your prayer is commanding the respondent to grant settlement in respect of the land.
My lord.
If that is the prayer, I'll have to dismiss your petition.
My lord,
Settlement can be given by the government, not by railways.
My lord, it's a government land, my lord.
Railway is not a government land.
My lord.
Railway land is not a government land.
My lord, there is a, my lord, difference between the railway land and the government cash land. We are in the government cash land. It is not the railway land. So, my lord, we are residing on the land.
No, no, no. You see the affidavit filed by the railways.
My
It
lord.
says that the petitioner encroached on railway land.
My lord.
That is the clear cut stand.
Without ascertaining that, my lord, whether it is a railway land or government cash land, we have.
You
have the
you're not
annexes.
you're not proceeding to evict them.
No,
Yes, my lord, they are not proceeding.
As per my affidavit,
But
Lordship,
they have-
they are going to issue notice, Lordship, under public premises.
Or they are still going to do it.
Lordship.
2022 matter. We fix it in 2025.
Lordship, the railway has asked them to, Lordship, vacate the land since, but they have approached this honorable court.
So therefore you stopped.
Lordship, stay order is there, Lordship. That is why.
No notice has been issued to us, my lord. My lord, there is a provision of filing appeal against the any step made by the railway authority under section 9 of the Premises Act 1971. My lord, we have the annexer 1. My lord, this goes to show that this is.
Where is your eviction notice?
Notice not issued,
No
Lordship.
notice has been issued to us. The railway staff has come to our place and
Yes,
asked
no
us
notice
to
has been
vacate
issued,
the
Lordship. They have
without any
taken-
notice. That is admitted by.
And Mrs. Devi, you don't know how to file a vacating application.
Lordship,
You don't know how to file a vacating application.
Lordship says reading is completed.
That's what I'm asking you.
Lordship.
2022 matter. We listed in the usual course. It's the end of the matter. It goes to the cold storage. It comes out after 6 years. If the railways have no urgency for their land, what can we do?
My lord, WBC 5866
The
oblique
proceedings
2015
in
is
this case is
pending.
completed. This is the matter for hearing in the month of July 2023.
Along with WBC number
No,
5866.
hearing I am not fixing any matter with any other matter because you see, I don't know what the status is. In view of the nature of dispute raised in this petition, the petition stands admitted for hearing by issuing rule returnable forthwith without requiring the petitioner to take steps. This is a matter for hearing on the month of July 2027.
My lord, we are in interim.
Interim
my
order
lord.
past study stands extended till the next date of listing.
God bless you.
33. Please, Your Lordship.
There's a request for upgrading two matters. Which matters were there? Naina? Just a moment, sir. What is it? Yes,
On the last occasion, my lord, 6/1/2023, my lord, responded checking time to file affidavit, but no affidavit has been filed, my lord.
yes, PWD.
Sir, context of non-payment of contract or bill.
Heard. Mr. K.R. Padgiri and counsel for the petitioner. None appears on call for the PWD. However, Mr. K. Govil and CC and Ms. G. Hazarika and standing counsel for the finance department is present.
I'm not interested in finance, but
Only for revenue and disaster
Oh,
management.
sir, the revenue.
Our proposal may be recorded.
Oh, revenue is not there, not Ms. G. Hazarika. Okay. None appears on call for the. Who will be appearing for this number two, Mr. Barua? Deputy Secretary to Government of Assam Public Works Department Budget Branch. Okay, that is PWD.
PWD.
Okay. Mr. Gogoi is for four.
Yes, my lord. Four, my lord.
No other sorry, no other respondents are represented. Next, by filing this petition under Article 226 of the Constitution of India. I said just before that. In this case, notice of motion was issued by order dated 11/5/2022. Until date, no affidavit in opposition is filed. Hence, the court is inclined to invoke the doctrine of non-traverse and presume that the claim of the petitioner is admitted by the respondents. Next para. By filing this writ petition in Article 226 of the Constitution of India, the case projected by the petitioner is that he was issued a formal work order dated 4/12/2009 for construction of roadside drain cum footpath and for providing roadside street light illumination in Naharkatia town, portion of Dibrugarh Rural Road Division. Where is that document? Where is the document?
My lord, kindly see page 18, my lord.
Page 18. Okay, from page 18, huh? Pencil mark.
Page 18.
Full stop. Next, the petitioner claims that the bid value was rupees 74,16,338. And out of the bid amount, bill amount of rupees 29,85,460 remains unpaid. First of, in this regard, the learned counsel for the petitioner places reliance on the construction completion certificate.
Page 30, my lord.
No, page 27 is there. Where is the date?
27 also.
Where is the date? Without any date, but signed by the preparing clerk on 21/11/2019.
19.
Post of petitioner also relies on the completion certificate signed by various signed by the chief engineer PWD roads on what is the date?
Date, my lord, 11/12/2014.
11/12/2014 and countersigned by the executive engineer PWD Jorhat Electrical Subdivision and Executive Engineer PWRD, Dibrugarh, Lahowal, LAHOWL, Moran, and Tingkong, TINGKHONG, Territorial Road Division. It appears that the bill was resubmitted on 2011-2020 within bracket annexure 6. Next paragraph. In view of the claim having not been denied by the respondents, the request stands allowed. The respondents are jointly and severally held liable to pay to the petitioner a sum of rupees 29,85,460, which shall be released within a outer period of 3 months from the date of receipt of a certified copy, a service of a certified copy of this order on the Chief Engineer PWD, Roads, as well as additional Chiefs Engineer PWD within bracket Electrical. PWD Roads is respondent number 5. 6. Electrical is 6. The petitioner shall
Oblige.
take up 2 matters which are request was made for upgrading. Which are items?
27.
Well, these are 2 applications under 11(6) of the Arbitration Act for appointment of an arbitrator. Well, the Dasti has been taken and it has already been served on the respondent, but nobody has appeared in the matters. It was, my lord, a project wherein, my lord,
Just
we were to do plantations. And accordingly, we have done this work. And, my lord, because the contract itself, my lord, provides that in the event they-
just a moment, just a moment.
Lordship,
Just a moment.
My lord, in this case, petitioners
Just a moment.
Well.
Is bench 4 is the assigned bench?
my lord, yes. Earlier it was done by the chief, but now, my lord, all bench 4s are taken because, my lord, Justice Michael had issued the, my lord, notice in this matter when he was holding bench 4.
It's okay. Yes, what do you want to say?
In this case, well, Dasti service was effected. My lord, I have been instructed to appear, but my lord, I'll be filing my wakalat number by Monday, my lord.
Okay.
Well, we have already taken Dasti. There is a section 9 application pending, wherein there is an interim protection. And here, my lord, everything now is in a quandrum. The issue is,
It's okay once they appeared.
my lord, if
Will-
my lord can have it on Tuesday, my lord.
No,
for-
not Tuesday.
Other than 8th, my lord, any day.
Either on 7th or on 9th.
7th, then,
I'll
my lord.
file wakalat number and I'll seek instructions. My lord.
7th, my lord.
Okay.
Let my friend have the instructions by 7th.
Okay.
It's an interesting contract, my lord. Once I have found here that the contractor can cancel, can terminate the contract.
No, every voluminous matters are interesting. Don't worry about that.
No, my lord, the conditions herein are unique, my lord, because it's
No,
a
that's
French
okay.
sponsored one. my lord.
That's
They
okay.
have brought in that concept here.
What was that issue? Ah, correct.
My lord is referring to the latest judgment.
No. I'm always in old good old days. Few things I should be discreet.
I got it.
Anything less than this would not be interesting. Correct. I think less than this will not be interesting. So if this concept is there, then is okay. No, not that interesting. I saw this will not be that interesting. Okay. So you can ask in a council, Secretary, sir.
Purvesh Bhutan.
Purvesh Bhutan.
Please write this back. Council for the Petitioner. Stop, Mr. D. Kuwait Leonard, Standing Counsel for the Forest Department, has submitted that he has been instructed to appear in the matter. And he pays for 2 days time to file his wakalatnama.
My lord, here there are two parties. One is a society which my friend will also be representing, and two is the divisional forest officer, forest.
No,
Both,
definitely
both, madam, both. 1 and 2.
Uh, you will file reply also within
No,
one
I'll
time?
come only instructions.
Instructions. It's only 11:06.
Okay.
Nothing
I
is there
have
to be
been-
disputed.
Briefly on in that way, madam, that they'll be sending some instructions, madam. Along with the wakalatnama.
Okay. Next one is agreed to by both sides. List on 7/6/2023.
For admissions, madam. What does this complaint?
Admission only,
No, this is come for orders, madam.
Acha, in the admission column. Okay.
Much obliged.
Acknowledged, madam.
48. No, this is how I spend my free time. Whatever I
I
have.
have to read that.
Huh?
This has also a connection to that same very place, madam.
Same. 48 same.
What do you say?
Hmm.
What is it?
Yes, item 34.
Yes, Your Lordship, we have filed our affidavit in reply.
You file it. Yes, what is the matter about?
Also, this issue relating to the issuance of a next of kin certificate to the person who claims to be the husband of the deceased. And in fact, here the petitioner has been preferred by the brother of the deceased lady. Inquiry has been done, detailed report has been submitted, whereby it has been established the person who has been previously issued with the NOK is not the legally married husband. There was no marriage which has been solemnized between the parties. Now,
Just a moment.
yes. Now here the petitioners, three petitioners, one happens to be the brother, other two sisters and brother, I suppose. Yeah, yes. So they are claiming that the NOK should be issued in their favor, but they objected to the previous issuance, which has already been cancelled. And that is established by the inquiry report also that has been conducted in detail. So affidavit has also been filed to that effect, annexing the inquiry report.
So the.
So now
So
the- Now,
next one is certificate for respondent number 2, 3 and 4 have been cancelled.
yes, not 2, 3 and 4. Five, only 5.
So 5 has been
Five.
cancelled.
Yes, 5 has been cancelled. He is claiming to be the husband, and in fact, it was previously issued and it has been finally cancelled.
So now what is to be done?
Done with regard to the petitioners,
They'll be getting it now.
yes, they will be getting. The report is clear as regard, because stepwise,
Where is that report?
report is page 26 of the affidavit that we have filed, and this the report has been submitted long time back. In fact, 26th of July, the report has been submitted to the Director of Land Records and also the additional DC by the circle officer. Page 26 is also close. This is the forwarding letter, and thereafter the inquiry report goes on. Concluding part is at page 33. Page 33, bullet number 3. You have nothing to say. You don't.
You see, despite everything, that's what I was confused. I was taking some time to understand. You see, still your writ petition has to be dismissed. You are for the petitioner. Just don't look back. You'll have to look at me. You see, your writ petition has to be dismissed.
I'm calling my senior.
Please do. After some time, let her come. It's a bail matter. APP notice.
Case about case that was called.
Where is the previous order?
Page number 17.
Page number
17, 17.
17.
There's a second application, my lord. And the first round is that
Just a moment.
later on, I came to know that she was suffering from mental disorder and one certificate also I have annexed here with my law.
Page?
20.
20.
That was prior to the marriage. In the year 2021, this document is off. Where she went to
We can't take cognizance of this.
my lord.
2 overwritings.
Regardless of psychiatrist clinic and the addresses are all genuine.
It's okay, but
But doctor's handwriting is such type.
this doctor will not make that. That correction. Doctors will not make such a correction.
My lord, here I am appearing, my lord. Here, as per instruction, my lord, charge sheet submitted in their case, my lord.
Charge sheet submitted. Oh. They need to go to the
My
jurisdiction.
lord.
actually. Mr. N. Anand then comes for the petitioner as well as Mr. Vidyut Sharma and the APP for the
Right.
state. Next, at the outset, the learned counsel for the APP has submitted that in this case, charge sheet number.
My lord, charge sheet number 76 of 2022, dated 30/11/2022.
In connection with Palasbari PS case number 131 of 2022,
22.
under section 306 of the 34 IPC.
Right.
Just under such circumstances, the court is intent to delegate the petitioner to appear before the which court? It will be CJM.
My lord. Kamrup Amin government.
So before the court of chief judicial magistrate, Kamrup Amin Gaon,
Amin government.
or an end of the court to any other jurisdictional court where the matter has been transferred.
Can it be reflected in the order that if the petitioner prefers a bail application that may be considered as per law? In
Oh,
accordance
okay. Because accordingly, it is provided that in the event the petitioner approaches the jurisdictional court, the same shall be considered in accordance with law.
My lord. Okay.
53.
Yes.
53. For correction, my lord.
Acha.
Correction of bail order.
Okay, the APP shall produce the case diary. Oh, this is from correction of the order.
My lord, correction of the order, my lord, already well granted, my lord.
Okay, what is the correction?
Perhaps father's name is defined, but in the orders.
No, that can be done.
Minus none. It is not.
Oh, no. None present call for the petition, for the applicant. However, Mr. Vidyut Sharma and APP is present. To stop.
May I please
In
your
view of the
53.
uh,
53.
office note dated 11/5/2023 by the Registrar Judicial, whereby the amendment to the cost title of the AB 225 of 2023 was permitted. This matter has become infructuous. According to this interrogatory application stands closed. Yes,
Lordship,
okay. Who's there in 53, Mr. Dhar?
Lordship,
This is your matter 53, we'll have to dismiss it.
Lordship, I will satisfy Lordship, let it come out.
No, because this satisfaction you can't make at any point of time.
Disputing that there is a living relationship.
No. You see your prayer, what is your prayer?
Yes, sir. But to immediately issue next of kin certificate in favor of the petitioners in respect of immovable properties and the movable property.
Can that be done?
Lordship?
Can that be done?
No, they have already issued.
Can that prayer be done, made? Can that be done? Can a next of kin certificate be issued for immovable property?
No, immovable property, because my late.
No,
sister-
I know because of that cause. You just tell me can a next of kin certificate be issued for immovable property? Can it be done?
Because Lordship, if your Lordship comes to the,
I'm just asking that question. Can it be done? I can go anywhere. Don't worry. But can it be done?
because
Can it be lawfully done?
there is a dispute, Lordship. Therefore, Lordship, there was an inquiry. to
No,
this
if
effect.
there is a dispute and next of kin certificate can be granted for property, then why is succession act there?
Yes, actually, it is there.
Perhaps the legislature doesn't know.
But the deputy commissioner, additional deputy commissioner has taken steps to issue the.
No,
next of kin
no,
certificate.
in NOK is only for debts and securities not more than 2,500. If you ask me where, I don't know. I don't remember it. These things I read 20 years back. I won't recollect correct it now. But as per the revenue circulars, NOK cannot be issued for property. So your writ petition will go. Wherever I go.
Since we are disputing, the Lordship will direct the petitioners to approach the civil court, Lordship.
I'll not even do that. You see, Mr. Dhar,
Lordship.
you'll have to find some time in your busy schedule to read your brief. Correct. Some time from the busy schedule to read your brief. Government has given an affidavit saying that your NOK will prevail. And then you are again saying that, please give me that.
No. That
You have
was
not even
kept in-
read.
That were kept in evidence, Lordship. That is.
No. You read that's what I said. You must take out some time to read your own brief.
Lordship, I'll, on 8th of June, Lordship.
No, you will do it. But will you do it after reading your brief?
Lordship, since your Lordship
You will
has
read.
advise me to go through the brief.
No, I will not advise you. I am beyond that. I'm just asking you, will you next argue with after reading the brief or without reading the brief?
Definitely we take.
Okay. It'll be rolled over. All matters will be rolled over. I have to have meeting, to attend.
Lordship, with regards to items.
Just one by one, just tell the court master, one by one.
Stay orders, continue.
Just tell him.
Please, your lordship,
With regards to item
44, there is.
He's the, as soon as I leave, my court master will be the deputy judge. Correct. So, but come one by one, give him some time, he will do it.
মোবাইলটো আপোনালোকৰ বহিখন
The second book.